Testing, testing. Morning, everyone. Welcome. Our first case for argument this morning is United States versus Coley and Duggar. Ms. Eisman.
May it please the court, Vanessa Eisenman for David Duggar. The primary issue affecting Mr. Duggar is whether there was sufficient evidence to convict him of drug conspiracy. There was not. The government did not prove beyond a reasonable doubt that Duggar and Betts had anything other than a buyer-seller relationship. This court has talked about two primary principles of drug conspiracy, being some sort of interested cooperation or a stake in the venture, like the two co-conspirators are working together, and some sort of an agreement to advance future sales. Betts' testimony confirmed that neither of those two principles were present here. As Betts testified, that these two men had a truly arm's-length relationship. Very importantly, Duggar paid cash every single time up front for the drugs that he bought from Betts, every time. And this was not a coincidence. Betts testified that he never fronted drugs to Duggar because he didn't trust him. He didn't know whether he would pay him back, so that's why he always asked for the cash up front. The two men also did not share any sort of information. Betts didn't know who Duggar's customers were. Duggar didn't know who Betts' suppliers were. Betts never gave Duggar any sort of direction about what to do with the drugs once he sold them. There was no sort of, he's working for me, I'm giving him directions, I'm kind of telling him what to do. They would haggle over the price every single time. There was no set price. And Betts knew that Duggar had another supplier. And so Duggar would use information from his other supplier to kind of get the price, to try to negotiate the price with Betts every time.
Didn't Betts say, though, that he had his doubts about whether or not Duggar actually had another supplier?
Yes, but there were text messages that confirmed that that's what Duggar told Betts, is that I have a main guy. And then he also said on cross-examination that he wouldn't have known or cared if there was another supplier.
But given that testimony, wouldn't the jury be able to find wouldn't they be able to basically believe Betts that Duggar didn't have another supplier?
Sure.
I mean, because you are here on a sufficiency of evidence standard, right?
And that's fine, but this is a totality of the circumstances analysis, and not having another supplier, that's not like a but-for regarding drug conspiracy. That would be just one factor. And even if this was an exclusive agreement, like what Betts testified to, right, when the government asked about what's your agreement, he says, basically, we were exclusive. I agreed to have drugs for Duggar, and Duggar agreed to buy drugs from me. Even if that were true, so assuming that the jury believed Betts that he said he didn't really have another supplier, exclusivity is not the same thing as drug conspiracy. It's not the same thing as having a joint agreement to further distribute drugs to others. That would just be, hey, I go to Walgreens for my prescriptions every single time, and Walgreens knows that I come there every single time, and I agree to keep coming back because I get such great service from Walgreens.
Except that's a legal transaction.
Yeah, you're right. But we're not disputing that there was, any drug distribution here. That's not in dispute, and that wasn't disputed at trial. The whole issue at trial was whether this was sufficient to see that this was anything more than a buyer-seller relationship. There was not a dispute. There was tons of evidence of drug dealing, and I'm not here to argue any of that.
Distribution quantities,
yes.
Repeated transactions,
yes.
Over a course of time.
Yes, and this court has said that those things standing on their own is not enough to show beyond a reasonable doubt that there was a drug conspiracy. This court has said there has to be something more than multiple transactions.
What about the other things the government does at least mention in its brief? There was advice given, things of that nature. Duggar asked for help at one point with respect to some difficult customers. He was counseled, or at least he was told by this guy Bates that about police presence were told on one occasion. What about all these things? Do they at least cumulatively make for the case?
No. This was like all in April. This was like 1 month, and a couple of those were even part of the same chain of text messages. Basically, what was happening is Betts saw some, I think, police presence at a hotel. Mr. Reitz can correct me if I'm wrong on these facts, but basically he said, you know, there's police around, don't go here anymore. Okay, that's as much self-preservation as it is, you know, trying to warn somebody or trying to help somebody with their business. Another time he said, stop showing up late. This is bad business. What he meant was he doesn't want to be him or his guys sitting around waiting with a bunch of drugs in a hotel parking lot or something like that. Stop showing up late. He even
But it
charges them
doesn't
more.
show that Betts thought your client was one of his guys.
No, he said he was one of his customers, and he didn't want to get caught in the parking lot just hanging out for an hour because Duggar was late. And then the thing
I
about
see.
asking for help, this was, again, one conversation, and I think it was joined with one of those other really little snippets. And he says, yeah, I've got these guys that are screaming my name, my government name or something like that. And he says, you told me that if I ever had problem with anybody, you know, just give them your names. And he's like, yep, I got your back. Betts testified that even at the time he says this, he had no intention of helping him
Tell me,
whatsoever.
Counselor Ed, with respect to our articulation of the law of conspiracy, do you see any particular ambiguities that you think we need to clarify?
No, I like our jury instruction. I actually think it's really good. I think ours, it really gives like two main things, right? Even if the seller knows that the buyer is going to resell, that's not enough for a conspiracy. That's way back in direct sales, U.S. Supreme Court case. That's really clear, and that's something that's confusing to the jury, right? They think, oh, he knows he's going to go and sell these drugs. That must mean they're working together. No, it's not. That's not enough to show that they had a joint criminal objective of further distributing drugs to others and of working together. And then that's kind of the second part of the jury instruction, the joint criminal objective of further distributing drugs to others. Again, in this sort of like hierarchy, what the jury needed to find is that Duggar was working essentially for Betts, and that's not shown here at all. He's not giving him any sort of direction. Oh, I'm sorry, I'm over time. Thank you. I would ask that you reverse the conviction.
Thank you. Mr. Kelleher.
Morning, Your Honors. Christopher Kelleher for the appellant Rick Coley. As this court knows, the concept of constructive possession is a legal fiction. In this case, tests how far into the realm of make-believe we should go. Rick Coley was found to possess a gun which no one ever saw him with. No phone or text evidence ever tied him to this gun. No witness testimony tied him to this gun. He never admitted the gun was his, never acknowledged its existence. So against this barren backdrop, what do we have? We have a shotgun propped in the entryway of a room. The door was open. Obviously the room was unlocked. There's evidence to suggest that Mr. Coley was sleeping in this room with someone else. Additionally, there were 5 other people in this home. Now, this home was not your standard house. It was more of a flop house. There were 3 rooms in the home. It was a small home. And the room that Mr. Coley was sleeping in was on the first floor. In addition, unlike virtually every other constructive possession case, Mr. Coley's belongings were not scattered in this room. There was no evidence that this was a regular place that he stayed at. As the record demonstrated, Mr. Coley was a man of no fixed abode. The gun itself, again, was in the entryway of the door. Most of these other constructive possession cases, as we made clear in the briefs, involve a situation where the gun is buried in a closet, put under a bed, hidden somewhere. That is not this case. And the fact, another distinguishing fact.
Why would that be important, that the weapon was hidden? I mean, it would, in a way, the fact that it was his room and the gun's out in the open right there seems to be a better case for the government. If it's,
Well, Judge Ripple, I respectfully disagree because that gun, we don't know when it was put there. It literally could have been put there as SWAT was surrounding the house saying, come out, and someone could have literally just placed it right there as they're walking out to basically absolve themselves or to frame Mr. Coley.
did your client ever admit he had a firearm?
He did not.
At no time.
He did not. There was a text from 18 months prior to the arrest in which he said to another co-defendant, it's good to have a pole, it's good to have a gun.
Yeah.
That's literally it. So the government is on very thin ice, and to reiterate the point about where the gun was, the reason I bring up in these other instances where the gun is hidden someplace, not only does it show that this gun was probably not accessible to other people, it was also likely that the dweller of that room, it was more likely there. So again, the fact that it was literally in the entryway of the door, any of these 6 people, including Mr. Coley, could have put it there. So in a lot of cases in which the court finds constructive possession, again, it's because of where the gun is, and it's, again, typically hidden someplace, which again would suggest that it's the room dweller.
Isn't this a question of inference for the finder of fact, though, as to whether there were sufficient indicia of control by your client or not?
Well, Your Honor, I would respectfully disagree because we need speculation. We need speculation that the gun was placed there by Mr. Coley. He had placed it there that morning. He had control. So, I mean, it is to a degree a fact-laden question.
Joint constructive possession is possible. So
Yes.
he does not need to be the one who placed it there. Constructive possession can be found if a jury so finds based on proximity plus dominion and control, ownership, etc. over the premises in question here, the bedroom. And there's no dispute this was his bedroom. And he, in fact, directed the police to that bedroom to go bring him some clothes from his closet. So it's clear that he had control over the bedroom. It was his bedroom. So it really doesn't matter if he placed the gun in the bedroom.
Well, Judge Sykes, I disagree on I would quibble with a couple points there. I agree, obviously, with the premise of joint and constructive possession. I recognize that. The issue here, though, I would submit concerns the substantial connection. And what is the substantial connection between Mr. Coley and this firearm? And that's, we really don't have anything here. And unlike these other cases where, again, there was some evidence that this was this person's room, and I would respectfully disagree that this was his room in the sense that it was a place he was sleeping. And I'm not trying to mince words, but this was a place certainly he was sleeping. But this wasn't a situation where, and the reason I point this out is because the court has emphasized this. In other instances, there's prescription medicine with the defendant's name on it. There's pieces of mail, there's bills, there's paperwork with the defendant's name.
He kept his clothes in the closet. He wasn't just an occasional overnight visitor. This is where he was living, and this was the bedroom that he was using.
Your Honor, I know that there was a closet there, and I'm not 100% sure how much clothes was there. And again, I'm not trying to circumvent the question, but again, if there's a closet full of clothes, I still think we're on strong ground. We can prevail, but I don't think that's the case here. Again, given his penchant for moving around, again, this was not. I don't think it was a place that he was necessarily living there. And again, there was another individual. The record's not entirely clear, but there was another individual sleeping in that room. And then again, you have 4 additional people in this small place, and with the room on the first floor. So I would ask that the court consider the confluence of all these factors and all these facts that just simply aren't present in these other constructive possession cases.
May I ask you the same question I asked your colleague?
Sure.
With respect to the the law of conspiracy, do you think there are any ambiguities in our circuit's articulation of the law of conspiracy that really need to be corrected?
I do not, Your Honor, and I would echo, Ms. Eisenman. She's much more knowledgeable about this issue than I am, but based on my more limited knowledge, I would echo her position, and I think it's fine. If there are no further questions, thank you, Your Honor.
Mr. Wrights.
May it please the court, Brian Wrights for the United States. This court has called it difficult in circumstantial evidence cases to distinguish between conspiratorial agreements and buyer-seller agreements. The record here, however, removes that difficulty because it includes direct evidence of an agreement. The conspiracy's local leader testified unequivocally that he had an agreement with both Mr. Duggar and Mr. Coley to sell drugs to them that depended on the further distribution of those drugs. The jury accepted that testimony, and the deferential standard of review to the jury compels this court to affirm. Even if that was
So
not...
you're relying on large quantities and repeated distribution, are you not?
So, as to Mr. Duggar's relationship with Betts, yes. All the other potential conspiracies have the three factors the court has always said that...
Is it true that we have said that's not enough?
Yes, but the court has also said it's indicative of a conspiracy. It's true that generally large-scale distribution, repeated distribution...
See, this is why I've been asking your colleagues about our language and our opinions, indicative of conspiracy, but it's not enough.
So,
what does that mean?
I was going to eventually reach your question, Judge Ripple, and I think my answer here is both yes and no. So we have litigated this case under the court's current body of law. We think that's sufficient for the court to affirm and for us to prevail here. Certainly, the court recently held an en banc argument where the government addressed what I think, in our view, is inconsistencies in the law. I think the attorneys in that case put the government's position better than I can. But for the purpose of this case, we are operating under the law as it is. Of course, if the court decides differently in Page, then that would apply. But we think we can prevail under the precedent at the time now, and we've not sought to change the law in this particular case.
Again, you seem to rely very heavily on the exclusivity of Duggar's arrangement with Betts. Am I right?
Yes, correct. So we think...
But we've said that's not enough either, right?
Yeah, the court has said a lot of things are not enough individually, but holistically, we think all this goes into the same bucket. So the one thing the court has been consistent on is that repeated distribution level sales with fronting equals a conspiracy, or the jury can infer from
That seems to be the
That's
bedrock.
the one thing we certainly can say. So Coley has that with Betts. Coley has that with Smith and Pennington. Duggar has that with Fielder. So all the convictions can be affirmed on that basis. It is true that Duggar only has 2 of those 3 factors with Betts, though we think the exclusivity sort of stands in the place of the fronting because operationally it's similar. If using Betts and Coley and Betts and Duggar, so Betts fronted the drugs to Coley, so he had an interest in Coley's redistribution because he stood to lose money if Coley didn't further redistribute those drugs. With Duggar, he didn't stand to lose money, but he did stand to not earn any money if Duggar didn't then redistribute drugs, make money, and then come back to buy more drugs. And the purpose of drug dealing is earning money. So I think really that ties their agreement downstream. The court also, Judge Ripple, you also asked about the other factors, and I want to focus a little bit on Mr. Duggar's request for protection. And if I may, I'm going to spin off Mr. Duggar's point about Walgreens. So if I buy prescription drugs from Walgreens, and then I sell those drugs, and I have a problem with the customer, if I contact Walgreens, they're going to say, whoa, that's a crime, and call the police. However, if Walgreens entertains that and then gives me advice, Walgreens is conspiring with me. So that in and of itself is the other factor beyond the large-scale and distribution-level quantities that goes to show that Mr. Duggar and Mr. Betts were cooperating with each other.
So, Judge Ripple, I think, raises a really interesting point, which is, this kind of thin line between conspiracy and transactions, right? And so particularly if you focus on large, regularly conducted transactions. If the seller in those transactions knows that the quantities he's selling is not for personal use, right? The only real use has to be distribution. Is that knowledge enough, or does the seller need to want the distribution to happen? And if so, what are the indicia that would change it from knowledge to want?
So I think the court has said the mere knowledge is insufficient. Now, I think in Page, the government maybe at least implicitly disputed that, but again, we're operating under that. The want is the need. So there is an interest. There has to be an interest in the further redistribution. I mean, the court previously has said that
Other than just money, right?
the knowledge could go to episodic transactions. So like if I sold someone drugs every 6 months and it's a lot, I would know that they were probably redistributing, but that may not be a conspiracy. But the repeated and large scale certainly ups it to a little more than knowledge. I mean, maybe it doesn't get you all the way to want under the court's current precedents. So at least as of now, the government has to add something to that. I think we've added exclusivity. We've added the cooperation based on the request for protection, the police warning, and the other business advice. And I think I, again, have to step back and say that Your Honor's question, I think, operates under the circumstantial evidence paradigm, and we have direct evidence here. So I don't know how the court could reverse when we have the leader of the conspiracy saying, I have an agreement with Mr. Duggar so that he could sell these drugs for me, and then we could both make money. That is an interest in the further redistribution of the drugs. If the court has no further questions on the
In the ordinary case, the kingpin isn't a government witness.
Correct.
We
yes,
got the kingpin here saying, these are my guys.
Yes, it is rare. I mean, I have not seen this testimony before because it can only arise when it's the kingpin. You know, witnesses have to have direct knowledge, of course, and most of the time the cooperators are a little lower and they can't say they have that agreement. As it notes here, Mr. Fielder didn't say he had a formal agreement with Mr. Duggar, even though the three factors were present and he was a conspirator. With that, I will just briefly move on to the drug count. I think that the conviction here is well within the court's precedents, like Kitchen and Richardson. I don't really have much to say factually other than I think Mr. Coley, one, is second-guessing the jury's verdict, and two, is trying to ignore the fact that joint constructive possession is possible. His arguments, I think, are strong for a jury. The jury could have accepted them. It wouldn't have surprised me if they did. But once the jury accepted our version of the events, the court can't reverse. And just before I sit down, I just want one point about the gun because the picture's not in the record. So this is the door. The gun is right here, similar to where one might put an umbrella when they're getting ready to leave. So Judge Ripple's point, I think that is more compelling because if you were trying to protect yourself, I don't know if Mr. Coley was right-handed, but most people are right-handed. It's right there to grab as he's coming out the door. So the jury could have relied on that factor too, especially coupled with the drugs.
Could I ask a question about the motion to sever?
You may, Your Honor.
We have said in our case law that you do have to establish a connection between the firearm and the drugs. And yet we also have case law that says there's a presumption with respect that there is a connection. I'm having difficulty reconciling those two lines of thought. It seems to depend on who writes the opinion. Can you reconcile those for me?
Here is how I read them. I don't know if this is the department's position. How I read them is there is the presumption, but if there's not something else, then maybe the presumption can be overridden. I agree. It's a little difficult to swear.
It's a subtle way of almost changing the burden, isn't it? The defendant's got to come up with something and say, "Oh no, there's no connection between the two."
Or perhaps the absence of something like Hubbard. I think Hubbard you could look at that perhaps the government does have to show a connection to upstand the presumption, or Hubbard we couldn't do so because there's 17 months between the two.
Let me Please, I'm sorry.
And here, we were able to show it because, one, the guns and drug paraphernalia were possessed at the same time the day the conspiracy ended, and there was evidence that both Duggar and Coley had guns during the conspiracy. So Mr. Fielder testified that Duggar had guns with him during drug deals, and then Coley, I agree, was one reference, but he did reference having a pole for protection.
He at
during the
least
court-
admitted that guns are part of
Yes.
this business.
Yes. So, however one looks at the burden or the presumption versus a connection, we've cleared that.
Well, I'm worried about our second obligation in these cases of, clarifying law. And, does the government really need a presumption here?
I don't know if it's neat. I think the presumption just flows from common sense. I think that's maybe why the court has said so. The court has consistently said that drugs and guns go together, so it's logical that in the mine run case they can be joined in an indictment. That, call it a presumption, call it something else. I think that concern maybe is better. I don't think the court needs to change its case law. That the concern when it arises may be better at the severance stage.
You don't, off the top of your head, know. I wouldn't. Have you? Do you happen to know whether other circuits use that language? Presumption.
I do not know, Your Honor. Sorry, I
Well,
did not.
that's. I'm really
I didn't-
taking you off the farm a little bit. I understand.
Yeah, I didn't
Okay,
research other
thanks.
circuits' case on that because I think this court's precedents are at least clear as applied to this case. So I didn't really look beyond.
Does the presumption have anything to do with Rule 8 and the joinder rule? That is, that counts offenses that are based on the same act or transaction are presumptively joined under Rule 8?
Yeah, I think the presumption is probably tied to Rule 8. Whether one looks at it that or the connection, I guess I think about it more of a connection. But that is tied to Rule 8 because if the court says, on one hand, that guns are tools of the drug trade, as it always has, and then we look at Rule 8 and it says, are these offenses connected? It's not really very difficult to get from point A to point B on that. I mean, call it a presumption, call it whatever. It is a logical, common sense finding. The court has no further questions. We ask it to affirm.
Thank you.
Thank you.
Ms. Eisenman, you had used all your time, but I'll give you a little extra time if you have something else to say in rebuttal.
Okay, I'll try to be really quick. Just in terms of the direct evidence, we made this point in our brief, but I just want to emphasize it. Please read exactly what Betts said the agreement was. He did not say that this is an agreement that we were going to be in business together selling drugs. He says, this is an agreement that I'm going to have drugs that Duggar can buy for me. And as long as I have that, he doesn't have to work with anybody else. That is not drug conspiracy. That is an exclusive, at most, it's an exclusive buyer-seller relationship. And
What
this,
if it is combined with the frequent selling of a large quantity of drugs?
No, not enough.
Why not?
Because it doesn't show that they're in business together. It doesn't show that they have any joint objective to kind of keep this thing going. It's done. He's paid him all the money that he owes him. That's what really distinguishes this case from so many others that this court sees. This is cash paid up front, and this is nothing about Duggar, go deliver some drugs to this guy, go give half of them to this, half of them to that. He's not giving him any sort of directions as if he's one of his underlings working for him. And it's not on credit. This is transactions that are completed at the end. Betts says he doesn't know or care where he gets the money or what he does with the drugs. He could consume the whole thing. Now, this is user quantity. I know that there's knowledge, but knowledge is not enough. And he says that I didn't know or didn't care, and of course he didn't, because Duggar's coming to him with cash all the time. So I would just emphasize that this is not the kingpin saying Duggar is one of my guys, I told him what to do, he sold drugs for me. That is not what he testifies to, and that is not what the rest of the evidence shows. Thank you.
Thank you. Mr. Kelleher, you had some rebuttal time.
I think 15 seconds.
Is that all it was? I'll give you a
yeah.
little extra time. I
That-
thought you had more than that.
That's fine, that's fine. Thank you. Very briefly, obviously, ultimately, the questions which the prosecution cannot answer, no one can answer, is how did that gun get there? Who put it there? When was it put there? And again, you have 6 total people living in this small house. Very different from these other constructive possession cases. And again, the gun being at the doorway, with due respect to Mr. Wrights, that shows anybody could have put it there. So again, I recognize the high hurdle. You know, the Seventh Circuit seems to be the place where constructive possession cases go to die. But again, what makes this case different is the number of people in this home, where the gun is located, and the lack of personal effects, other than clothes, personal effects that typically permeate these other cases and which heavily influence the court's decisions on these cases. So again, we respectfully ask that the court reverse on this issue. There are no further questions?
Thank you very much. Our
Thank
thanks
you.
to all counsel. The case is taken under advisement. Our second case this morning is the United States against Austin McLean. Mr. Roy, good morning.
Excuse me. Good morning. May it please the court, opposing counsel, attorney Michael Roy, on behalf of appellant Austin McLean. McLean's trial and conviction suffers from a number of infirmities. I understand that some of our individual complaints, such as talking about hearsay rulings, may seem a bit nitpicky. But as a whole, everything together, it's the cumulative effect of these errors that we think warrants reversal. And I think what differentiates this from other cases where people have claimed cumulative error is that all the errors are linked together. They all involve the same element in dispute at trial, whether Austin McLean had the intent to commit the offense. First error being the expert testimony, which went directly towards intent. Second error, again, the hearsay ruling is directly about intent. The jury instruction we challenged is about intent. And then the prosecutorial misconduct claim, again, that goes to Austin McLean's testimony, which was about intent. So it's all linked together as sort of one cohesive argument. I plan to focus on what I think first is the biggest issue, the expert testimony, unless this court has any questions about other claims. So our view is that this is a legal error. The district court erred not in weighing the evidence under Rule 4.3. This is not an on-the-spot judgment where the court said the prejudice outweighs the probative value. Reading the district court's reasoning as a whole, the implication is that the court applied what it thought was a bright-line rule, that any expert testimony on intent needed to directly negate specific intent, rather than just be towards an intermediate fact that could be used to generate a chain of inferences towards negating intent.
What was the precise purpose of, what was the reason why the defendant wanted to offer this testimony? What does it go to?
Sure. And there's 3 different purposes for the testimony, but the one regarding negating intent, that's that McLean, he had his own version of events testifying what his motive was going there. And I mean, as the government points out, this is a very common thing for defendants to say in these types of cases. It's completely irrational that someone would say, oh, I met an underage teen on a dating app, I went to rescue them, right? No rational person would take those steps.
So I guess the reason I ask is because the briefs seem to focus not on whether or not on McLean's capacity to have that initial bad decision, but his, after forming that purported intent, that is to go and rescue Cody, that he then took steps that were nonsensical.
Exactly.
Right? And so is the expert designed to go to both issues, or one of those issues?
The expert's definitely not going towards a diminished capacity defense. It's not there to say that.
So it's not the first one, it's the second one.
Yes, it's purely that once he had his intent, he did an irrational set of steps to do it. And I mean, there is evidence that, quite a lot of evidence actually, that he had plenty of reason to know the profile was fake, which is pretty strange. I mean, they searched his phone afterwards, found the GPS spoofing app. There was evidence at trial that if you use the GPS spoofing app, you can tell that all these brand new profiles are in the same house. I mean, a normal person would look at this and be like, why would you go there? That's obviously fake. Most likely it's a sting operation.
Well, I guess reading the district court's kind of decision process as a whole, I think it may have been different if Dr. Wilson's opinion was exactly that once he decides on an ends that his prior stroke and diminished capacity and inability to make good decisions hampers his ability to figure out what the appropriate means is to that end. But it wasn't that specific. It was so general. It was that he had bad decision-making capabilities. And so why shouldn't we defer to the district court's reasoning that, that might confuse a jury to think that Dr. Wilson was being offered for the first issue, diminished intent, as opposed to the latter?
I have two responses to that, Judge Lee. The first is I would point to page 26 of Dr. Wilson's report, where it is a bit more specific than you stated, in that he talks about doing the Iowa gambling task, and it's specifically about his ability to assess risks and awards for new scenarios, which would be what this situation is. He has a new scenario. He assesses risks and rewards improperly. What inference to draw from that is more of something for the attorneys to hash out rather than an issue of admissibility. And then the second point is that whether it confuses the jury or something, I just reread the district court's rulings this morning. I don't see where the district court discusses the prejudice that outweighs the probative value. The government treats prejudice as self-evident, whether it's confusing the jury or unfairly prejudicial. Government treats it as self-evident on appeal, but most of their arguments seem to boil down to it's prejudicial because it helps McClain, which is not unfair prejudice. Every piece of evidence is going to help somebody, otherwise no one would try to put it in at trial. I'd also move on then to the second purpose, or one of the other two purposes for putting this evidence, which is the demeanor evidence. And Austin McClain, he has very visible physical disabilities, speech problems. A lot of this can't really be captured in a transcript. Things like unequal pauses, weird word-finding problems. Transcript doesn't capture when he makes weird pauses during his speech. And it certainly doesn't capture the different physical tics and things that could be seen as nervousness to a jury. And the district court's reasoning for saying that expert testimony was unnecessary on this ground, that strokes are commonplace, really doesn't address the issue. Because the issue isn't whether individual jurors are familiar with strokes or have a family member who suffered from a stroke. Almost everyone has. But everyone's stroke is different. And there's evidence in the report that Austin McClain's stroke is an outlier. I mean, he was hospitalized for 3 months. That's way above the average of just days. A study of people with similar types of strokes have a 50% survival rate. This is not the run-of-the-mill commonplace stroke.
The trial judge did permit your client to testify as to his stroke and the results of it. Did she not?
She did allow him to, but I don't think that was a remedy to the issue, simply because Austin McClain is the one with the communication difficulties, and then at the same time, he's required to express his own communication difficulties. He's not as capable of expressing the issues as an expert would have been.
Well, in any event, the expert testimony would be corroborative of his claim. Am I right?
I mean, it would be corroborative. It would also be go much further than what Austin McClain said. I mean, he could say generally, I remember being hospitalized for a long time. I still have issues. But that's different than an expert or a doctor saying, yeah, he specifically went through these steps. We see these issues in his treatment still. And I think this particularly goes to Dr. Nair, the treating physician, who was not a retained expert, would have appeared under subpoena just a completely neutral doctor talking about the treatment of Austin McLean, that would have been exactly the type of thing where it's just a sort of boring statement of his symptoms rather than anything editorialized by the defense.
Tell me, and I'm taking you a little bit broader scope here than you announced you'd like to stay on. Given the exclusion of the expert testimony and given the exclusion of the statements which the district court deemed to be hearsay,
Sure.
what did you have left in terms of mounting an affirmative defense?
We had left somewhat of a lesser version of it. We had Austin McLean communicating himself his own stroke issues and trying to explain his demeanor. But again, he's the one with the communication disabilities, and he comes off as not credible. So that's not really a good substitute. And then in terms of the hearsay rulings, again, it's the court repeatedly instructing the jury to disregard him talking about what we say are not statements offered for their truth, but to explain where his history comes. And I mean, the narrative the defense was trying to build is, right, here's a guy who he has a big part of his personal identity, long history of doing volunteer work, working for anti-trafficking organizations. There's personal embarrassment that he had a stroke in his 30s and is now stuck on disability benefits. So there was a strong motive for him to have the intent he offered here, but a lot of the details that would have fleshed out for the jury why that intent existed were missing.
So that's in effect, your claim that this couldn't be harmless error.
Right, and I mean, I recognize, I think the hearsay is a good example that if the hearsay rulings was the only error, we probably would not be raising it. That would be a very difficult burden to overcome on harmless error. It's the cumulative effect. And for that reason, I'd also like to move on.
In other words, the district court took a fairly aggressive view of your case.
I mean, I would say so. I don't want to say that we're not saying the court was biased or anything like that,
no.
but it's the effect of the individual rulings combined. And again, all going towards the same set of issues on intent in the defense.
Let me let you get back to what points you want to make, but before you sit down, I hope you'd say a few words about this argument of counsel. I find it disturbing.
That's exactly what I was going to move on to, Judge Ripple. In terms of the prosecutorial misconduct, we think the first prong, whether there was misconduct, is pretty clear cut. The government does not cite any cases in which a prosecutor accused defense counsel of committing a crime, much less a felony. Members of this panel might remember the Bo Brindley case. There was a defense attorney literally prosecuted for the exact same thing the prosecutor said the federal defender did in this case.
Let me, if I can focus you a little bit.
Sure.
With respect to the Doyle era, did the district court's instruction to the jury, or the striking of the first couple of words, did that cure the Doyle era?
Only in part, for two reasons. First, there's always going to be the issue of whether the bell's already been rung, and then it goes into the different 5 or 6 factors from Darden. But on top of that, also left in the point that it was a long time waited. Although we think that the stronger...
Well, the jury still heard that, right?
Exactly.
In other words, that they had a long time to come up with this.
Right, yes, they definitely heard that. And we also think that the stronger problem is that defense counsel helped him make up the story. That's the worst comment, particularly since the district court did not issue a corrective instruction on that comment. And I think it's telling that the government has to rely on primarily plain error cases, which this is not a plain error case, that changes the analysis on harmless error. We don't have to show that acquittal.
Terribly immature thing for a assistant United States attorney to do.
I agree, absolutely, Judge Ripple. This is, I think it would have been very easy for them to instead just attack Austin McLean or his testimony. And I mean, even if they had used rough tone, if it was just about how outlandish, or if they even said that his defense was stupid, that wouldn't be an issue.
That's fair game.
That's fair game. The issue
Right.
is saying that his attorney helped manufacture the evidence, which again is a felony, just as saying perjury yourself is a felony.
But then again, we come to the harmless error issue. Was Why isn't this harmless error?
For the jury instructions, because it's been preserved, it's not plain error, we don't need to show that he necessarily would have been acquitted. It's more whether the trial was fair. And I'm happy to march through the various factors from Darden, but I think the big points are, first, this was a preserved claim. Most of these prosecutorial misconduct claims are either not preserved or they were preserved, but there was a corrective instruction. It's pretty rare for there to be a overruled objection when there is still misconduct.
The main factor in Darden, though, is the strength of the evidence, right, against the defendant. That's kind of, and here we have the text messages, we have kind of all the facts kind of leading up to Mr. McLean arriving at the home. It seems like there's a lot of evidence that would go against your client in this case. And isn't that one of the Darden factors? And I think we've said that's one of the most important Darden factors, right?
I don't know if I would say it's the most important, but I agree, there is a lot of evidence. However, looking at the other factors, they almost all certainly weigh in McLean's favor, or at least our position. And regarding the strength of the evidence, that goes back towards cumulative error. And more broadly, I think there is different ways to look at the evidence. It wasn't, certainly the jury could find him guilty based off this evidence. They weren't required to. And there is also the third option, which is something similar to what this court said in Gladish, that he could have had an intent to sexually excite himself during the initial conversations in a role-playing manner before he knew or was certain that it was a real person. There's plenty of evidence that he thought the profile was fake. He talked about other people having fake profiles to trade pictures. So he could have had a shifted intent at some point where maybe he would have wanted to get sexual excitement and then changed gears. I see my time is up. I'll sit down. Thank you.
Thank you. Mr. Simpson.
Good morning, Your Honors. May it please the Court, I'm Scott Simpson on behalf of the United States. I intend to address first the District Court's exclusion of the expert testimony, then I'll move straight to the prosecution's rebuttal argument. We contend here, Your Honors, that what we are talking about here is reviewing a discretionary ruling under Section 403. Now, admittedly, part of that discretionary ruling under Section 403 obviously is the assessment of the probative value of this evidence, but ultimately the District Court was relying on Section 403, and that's what we're reviewing here. At the May 26 hearing, defense counsel himself said, quote, "The only argument they, that is the government, made was Rule 403. That's on page 10 of the May 26 transcript. And shortly after that, the District Court said, "I do want to, I guess, clarify my ruling that the crux of it really is 403. That I don't find that to the extent it is relevant to create an inference to negate specific intent," I'm skipping a few words here, "that its minimal probative value would outweigh the prejudicial value of all the reasonable inferences under 403. In fact, there were 3 hearings at which the parties and the court discussed the government's motion in limine on the expert testimony, and among all 3 of those occasions, Rule 403 was the only rule of evidence that the District Court actually referred to. So this is a Rule 403 decision that we're reviewing here.
On the prejudice side of this scale, what was the government's argument for undue prejudice? Or confusion of the issue? I mean, it's a balancing test, right?
Yes, Your
Probative
Honor.
value against the prejudicial effect, or confusion of the issues, or the other factors that are
prejudicial
in the
effect.
rule. What was the government's argument? It's not really clear from the judge's oral ruling
Yes.
what the nature of the prejudice.
Yeah,
there is some reference to confusion of the issues.
Yeah, and I would all of the judges' rulings here were from the bench, so we're looking at a transcript, and I should say that obviously sometimes when the judge is ruling from the bench, it's a little hard to see exactly what the judge is saying. Sometimes the judge misspeaks. We don't even know if all the transcripts are completely reliable.
That's why I'm asking about the government's argument, because the judge obviously sided with the government, so we might get some
Yes, Your Honor.
insight into the nature of the prejudice by knowing what your colleague argued.
Yes, Your Honor. We're talking about confusion for the jury. We're talking about the possibility of a mini trial on whether the defendants had a reduced decision-making capacity. We're talking about the government's filings talked about this, the potential for engendering sympathy for the defendant. And I think it's especially important that not only are we talking about reviewing an evidentiary decision here by the district judge, but we're talking about an evidentiary decision in relation to a medical doctor. The court has talked about the aura, I believe it's the aura of special reliability that expert testimony sometimes has. I think that's especially important in relation to a medical doctor. If you bring in, and we said, as we noted in our brief, this case, we're obviously not talking about a Social Security case or something like this. In this case, the defendant's medical condition is not part of the elements of what we're looking at here.
To that point, there was some discussion obliquely on the record about diminished capacity and whether this was an attempt to mount a diminished capacity dissent, and that was denied, that it wasn't really a diminished capacity defense, I should say, and in the formal sense that it was testimony offered to explain his innocent intent, or
explain-
his
to
defense of an
explain his
innocent
decision.
intent, that this was a
Yes.
rescue mission, this was not sexually predatory behavior. So I assume that was part of what was briefed before the court? I haven't looked at the underlying briefing.
I believe in the government's initial motion in limine, there was some discussion about a diminished capacity defense. It was unclear. So what prompted the government's motion in limine was the defense sharing Dr. Wilson's expert report, and so the government couldn't completely see, just based on the report itself, what the defense was planning to argue. So we initially thought it might be a diminished capacity defense. So in that initial motion, there was some discussion about that.
see.
And then the defense came back and said, no, it's not diminished capacity. It's trying to explain this bad decision by the defendant. And so that's what we're talking about on the prejudicial effect. So in the course of making that Rule 403 ruling, the court looked at the prejudicial effect and also at the probative value. One of the things that the government said, and I believe Judge Lee made this comment, the district judge said, it's such a general statement that the result of the neurocognitive deficits is that he does not have the ability to make sound decisions. And the court went on, I find that it's just too far afield from being directly probative, or even to the extent that it is relevant or probative, to link it up to creating an inference that would somehow negate the specific intent required for this offense. So I think what the judge is saying here is, what are the elements of this crime? Obviously, any evidence that's being submitted or being offered has to be related to one of the elements. And the court is saying one of the elements is intent to persuade. So the court is assessing whether the proposed evidence here, the expert testimony, tended to make the defendant's intent more or less probable. And the court simply expressed doubt about that, because the proposed evidence about diminished capacity, decision-making capacity, the court said was too far afield from being directly relevant to that issue of intent. In other words, the court is saying, I think, that the defense failed to establish any connection between that allegedly poor decision-making capacity and the alleged intent to rescue a victim. So we have that assessment of the probative value, that assessment of the prejudicial effect. So again, what we're assessing here, what we're reviewing here, is that Rule 403 balancing, to which this court owes substantial deference. I should also address, in relation to the demeanor, I believe that came up in the defense's argument. In relation to explaining the Mr. McLean's demeanor or communication style, the district judge herself saw Mr. McLean and could judge whether any testimony was needed, any expert testimony was needed on that subject. In fact, there were at least three occasions when Mr. McLean attended a hearing in person before the judge issued its ruling on the motion in limine, and there was an additional occasion in which Mr. McLean appeared by video. So the judge had ample opportunity herself to assess Mr. McLean's demeanor, Mr. McLean's communication style. There was at least one of those hearings where he attended in person, where there was some colloquy between the district judge and Mr. McLean. So she herself could assess his demeanor and communication style and assess whether any expert testimony was needed for that. We would suggest, Your Honors, this is a discretionary call, reviewing for abuse of discretion. We would suggest that even more than a lot of other discretionary issues, we're talking about a judge who's assessing the demeanor and communication style, communication skills of a defendant. Even more than a lot of discretionary questions, I believe we need to defer to the district judge on that. If there are no further questions on the expert testimony, I'd be glad to move to the issue of the rebuttal argument. The defendant's challenge here on the rebuttal argument we submit boils down to 4 words, the inclusion of 4 words, and his defense counsel. The court has made clear that there's nothing wrong about saying the defendant has fabricated his story, even saying the defendant's version of events is ridiculous, is garbage, and so forth. This court has approved that kind of thing where the evidence supports an inference that the defendant has lied. And the evidence here powerfully supports that inference. Mr. McLean said he was just trying to rescue someone, but right after he learned Cody's age, McLean said, "Nice, ha ha." And several seconds later, he said, "Should we take this convo elsewhere?" And once they moved to texting, McLean asked Cody whether Cody's male genitalia was nice and whether Cody had a picture of it. And McLean sent Cody a picture of his own genitalia. And later, McLean told Cody that sex is, quote unquote, more fun without a condom. And he sent Cody another picture of his genitalia. Those are definitely not the words or actions of someone who's merely trying to rescue a minor. And in fact, at sentencing later, the court applied the enhancement for obstruction of justice based on that false testimony by the defendant. And on appeal, in fact, the defense does not challenge that sentencing enhancement. Now, as we said in our brief, certainly it would have been better if the prosecutor had not included those 4 words, had not referred to defense counsel in its rebuttal argument, as opposed to just referring to the defendant himself. And let me be very clear, since I think this came up in the defense's reply brief, let me be very clear. The government certainly was not at trial and certainly is not here on appeal accusing the defense attorney of suborning perjury, far from it. But in the overall context of this trial, those 4 words did not deprive the defendant of a fair trial. The main target of that comment was the defendant himself. He's the one who had given that testimony. And in resuming his rebuttal argument after the sidebar about the reference to defense counsel, the prosecutor did not, in fact, repeat the assertion of untruthful testimony. And of course, one of the factors...
The entire statement should have been stricken, I think.
Except, Your Honor, as I said, this court has many times approved saying that the defendant has given false testimony.
The defendant, not that the defense counsel suborned perjury, which is what
Obviously, if the district judge had said, strike those 4 words and his defense counsel, we wouldn't be here. So presumably the district judge could have done that.
So that part of the rebuttal opening was improper.
That's what we're here for. And as I said, it would have been better, definitely would have been better if the prosecutor had not included that. But what we're talking about here is
So that's not a
prejudice.
confession of error, it was unwise.
It was unwise. It was unwise, yes, Your Honor. But in the context of this case, we submit it did not deprive the defendant of a fair trial. It was directed primarily at the defendant. In resuming his rebuttal argument, the prosecutor did not repeat that assertion of untruthful testimony. And of course, one of the factors in assessing allegedly improper comment in closing argument is what the weight of the evidence. And here, the evidence against Mr. McClain was overwhelming. In addition to what I already talked about, later on in the conversation, in the text conversation, they talked about taking prophylactic medication, and I apologize for my language here, but Mr. McClain said, you take that and you can fuck without care. And lastly, when Mr. McClain, when he was approaching the house where he was hoping to meet Cody, he asked, can we kiss when you get in the car? So the evidence was overwhelming. And for those reasons particularly show that those 4 words did not deprive him of a fair trial. Mr. McClain's own statements and actions toward Cody were far more powerful than anything the prosecutor said. So unless the court has questions about the hearsay, the rulings on hearsay, we would rely on what we said on our briefs, and we ask the court to affirm.
Thank you.
Thank you.
Mr. Roy, I think you used all your time, or almost all your time. I'll give you some extra time in rebuttal.
Thank you for the extra time. I'll just make some quick brief points. Regarding the Rule 403, Judge Sykes, you were asking the question about prejudice, which I had the same difficulty with what the court's reason was on prejudice. And the government's answer, and the government did make arguments below about prejudice, but it's kind of a kitchen sink approach. It's just like almost listing everything that's in Rule 403 that could be prejudice, confusion, wasting time.
Well, considering the procedural posture, the government was not in possession of the expert's report, didn't know exactly what the expert was going to testify to, didn't know exactly what the purpose of the expert's testimony was when it made the motion in limine, if I'm understanding this.
They did have the report, Judge.
Right.
They had the report, but they didn't know what the exact arguments were going to be, which is why they framed it as diminished capacity. And then the government correctly described what happened. Diminished capacity, defense responded, that's not what we're using it for, and then continued briefing from there.
Okay, so it was kind of a moving target, so to speak, in
Right.
terms
There
of...
were 2 rounds of briefing, though, however. And then on appeal, the government using the kitchen sink approach. I think that our view that the court was applying a bright line rule, the clearest example is on page 17 of the appendix, where the judge says this is not a proper purpose for expert testimony. And then I'd also point to this court's decision in West, where it reversed on a similar sort of claim. If there's no further questions, I'll sit back down. Thank you.
All right, thank you very much. Our thanks to both counsel. The case is taken under advisement. And before we move to the rest of our calendar this morning, the court will take a very brief recess. All right, our next case for argument this morning is Sparger Withers versus Joshua Taylor. Mr. Getch.
Thank you, Chief Judge Sykes, and may it please the court. This case presents a challenge to the defendant's system of contingency fee forfeiture prosecutions. And starting with mootness, if I may, as we describe in our briefs, 3 separate grounds confirm this case's justiciability. First, as to Ms. Sparger Withers individually, there is the voluntary cessation doctrine, which maps neatly onto the recent FICRE decision. As in FICRE, Mr. Taylor's contingency fee arrangements remain unchanged, and again, as in FICRE, nothing prevents Mr. Taylor from violating Ms. Sparger Withers' due process rights again in the future. Second, as to the class, there is the inherently transitory doctrine, which calls for a straightforward application of this court's Olson decision. And finally, there's the picking off doctrine, which the Fifth Circuit in 2020 applied to a putative class action challenging the constitutionality of a civil forfeiture regime. So I think really under any of those 3 standards, this court can be confident that it has jurisdiction to reach the merits. Now, on the merits, the party's main ground of dispute is whether the due process clause imposes any standard at all constraining prosecutors from having a direct and personal financial stake in the cases they prosecute. And our bottom line is that Marshall versus Jericho confirms that there is absolutely such a standard. That standard certainly is not as stringent as the due process standard applicable to judges under Toomey versus Ohio, but it is nonetheless a real standard. And the majority in the Louis Vuitton case, I think, clearly recognized that at page 807.
Let's talk about the justiciability issue for a few minutes.
Certainly.
Why I'm not too sure I understand why this is not moot. I mean, plaintiff's out of the case. Am I right? The plaintiff is out of the case.
The morning after we served Mr. Taylor with process, he voluntarily dismissed the state court action. Yes, Judge Wright. And the reason that's not moot, and again, I think we're focusing here on the voluntary cessation doctrine. I'll leave the other two.
Right.
Yeah. The reason it's not moot is for a couple of reasons. First, Mr. Taylor dismissed that case without prejudice, so nothing under the trial rules prevents him from refiling it again. Now, at times, the defendants have suggested that there's a 2-year statute of limitations that acts as some kind of rule barring a refiling of the case. In fact, and we fleshed this out in response to their latest 28J letter, in fact, it's not at all clear that a 2-year or a 5-year limitations period might apply. Ultimately, it would have been entirely within Mr. Taylor's discretion whether
But he hasn't refiled the case.
No, he is not, Your Honor, but I think the critical question under the voluntary cessation doctrine is whether he has the authority and the capacity to refile that case. And certainly the defendants haven't carried their heavy, stringent, and formidable burden of
Suppose he files the case again. Do we know that he's going to dismiss it? If you bring a lawsuit again?
I don't think we can possibly know, and it's precisely because he has that kind of
There's nothing inherent in the situation that says it would necessarily become moot again, right?
There is no inherent time limit on how long a civil forfeiture action lasts, and I think that goes more to the inherently transitory doctrine, Judge Ripple. But there was likewise nothing inherently limited in how long a detention in Tippecanoe County Jail would last in the Olson case. In that case, for example, 41 inmates at Tippecanoe County Jail stayed in that jail for more than a year. But what mattered for this court's inherently transitory analysis was that whether any particular plaintiff might get transferred rested entirely in the government's discretion. And if anything here, I would submit that Mr. Taylor has far more discretion to jettison any particular inconvenient forfeiture case than the prison bureaucracy had to transfer any particular inmate in the Olson case. So I think under Olson, this is really a straightforward candidate.
So you rely on the Olson case as your key authority?
Under the inherently transitory doctrine, yes, Judge Ripple. Under the voluntary cessation doctrine, I would point you to FICRE. But yes, I think this maps neatly onto the Olson case, particularly in light of the Supreme Court's decision in Nielsen versus Priap, where plurality certainly applied the inherently transitory doctrine where the actual detentions could last for a year or even longer. So I think kind of all roads lead to Rome here, and whichever of those 3 justiciability doctrines we're talking about, I think this court can be confident that there's a live controversy here. Now, if I may, I'll touch briefly on the merits, because I think the party's main ground of dispute is whether there is any due process standard that applies to prosecutors. And we submit that Marshall versus Jericho embodies such a standard. The defendants, and I think the district court's main response to that, is to charge us with, I think the phrase was casting aside history and trying to substitute our own policy preferences for those of the legislature. But to be clear, our submission is not that the court should ignore history. It's that the court should apply the standard set by the Supreme Court. And here, for this court to adopt the defendants and the district court's kind of historical view of the Due Process Clause, I think would necessarily break, certainly with the 11th Circuit's precedent, likely with the 5th Circuit's, the 2nd Circuit's, and for what it's worth, with the views of the U.S. Department of Justice. Now, for that matter, I do in fact think that the historical narrative here supports Marshall's standard in much the same way that the historical narrative supported Toomey's standard in Toomey versus Ohio.
What is the Marshall standard in 2 sentences or less?
Certainly. So I think it's best understood as obviously less stringent than Toomey's, but when there is a financial stake or some other kind of conflict that gives rise to a realistic possibility of distorting the prosecutor's judgment away from pursuing the public interest. And there may well be difficult questions at the margins, but I think the Supreme Court in Marshall and other courts since then have recognized that when the prosecutor has a direct personal stake in kind of, they get paid if they win a case and they don't if they don't, that's a paradigmatic example where the prosecutor has an interest in winning and maximizing how much they win. But the government's interest, under our system of ordered liberty, is that justice be served and that the government's agents steward the public trust.
But the court in Marshall did not say anywhere that it was recognizing a due process duty on the part of the prosecutor to be free from a financial conflict of interest, in the same way that it announced in Toomey and the Toomey line of cases a due process duty on the part of judicial officers, adjudicators, to be free from financial and other conflicts of interest, as Toomey has been applied to other contexts going forward, including in Caperton campaign contributions. And the court specifically disclaimed that it was pronouncing on the contours of the due process right in question here, because any suggestion of improper influence or bias based on the scheme that was challenged there was so attenuated or remote that the court didn't have to pronounce whether there was a due process violation. So, I mean, that's how the decision reads to me, because there's lots of quoting from Toomey that prosecutors are different and the reasons why prosecutors are different, and so we don't have to announce a due process principle here, because this case isn't even in the ballpark.
Well, so I don't think that's quite right, Your Honor, because if you look at page 249, the court does say that prosecutors are public officials and they, quote, must serve the public interest. But I think to answer your question perhaps more directly, it's certainly true that the court did not kind of elaborate comprehensively and with precision, is the court's words, kind of the contours.
It didn't really announce a constitutional principle at all, much less elaborate on it. It didn't say that there's a due process interest that's implicated when the claim rests on a prosecutorial conflict of interest.
Yeah, so respectfully, I think that's the only way to make sense of what the Supreme Court did, certainly in Section 2B of that opinion. And I'll note parenthetically that, of course, the 11th Circuit has taken that view, the DOJ has taken that view. So
the 11th Circuit really misstated what was going on in Marshall, including misquoting Marshall. And rely to the extent that the 11th Circuit was relying on the Louis Vuitton case. That was a supervisory power case, not a due process case. Justice Blackmun wanted to make it a due process case. It wasn't a due process case. It was all resting on the court's supervisory authority over the lower courts on matters of contempt.
Sure. So I don't disagree with you on that being the bottom line.
So to the extent that that was the 11th Circuit's authority, doesn't help.
Fair enough. I won't belabor the 11th Circuit's position. Then I will note, though, that if you look at page 807 of Louis Vuitton, and I grant you it's a supervisory case, the court spent a paragraph characterizing Marshall specifically and described it in a way that I think is fully consistent with our view. That's at page 807. But setting that aside and addressing, I think, Marshall on the merits, I think the only way to understand what the Supreme Court in Marshall was doing in Section 2B was analyzing whether there was a realistic possibility of distorting the prosecutor's judgment away from stewarding the public trust and towards impermissible considerations like financial self-interest. Yes, sir.
There's a difficulty I have with that kind of interpretation of Marshall is I agree that to the extent that I believe Marshall said that it could be a due process violation, it could be raise constitutional issues, right? A scheme injecting a personal interest, financial or otherwise, into the enforcement process may bring irrelevant or impermissible factors into the prosecutorial decision and, in some contexts, raise serious constitutional questions. So it left open the possibility that in certain circumstances, it may have constitutional implications. But I guess I'm with Chief Judge Sykes, and I don't really see a rule being announced in Marshall. But let's say, given the time constraints, that let's assume that Marshall does not announce the discrete confines, right, of this due process rule in this instance. The district court then went on to look at Medina and to look at history, as you say.
Yes.
And so do you have any response to that?
Yes, absolutely, Judge Lee. And I think the bottom line here is that even if we were starting from scratch, and again, I would submit that we're not, but even if we were, I think history likewise supports our reading of Marshall's standard here. Because as I read the defendant's brief around page 26, 27, they don't dispute that a traditional part of our criminal justice system is that the government and its agents have to steward the public trust. I don't think there's any dispute on that. And to that extent, I don't understand the defendants to be defending the judgment below. And if you look at history, I think the arc of the 18th and 19th centuries is fully consistent with Marshall's proposition that prosecutors, must serve the public interest, and that that principle is subverted when, again, in Marshall's words, when a prosecutor is financially dependent on the maintenance of a high level of penalties. So, for example, if you look at some of the law review articles that we point to in our reply brief, from the founding or even before, the American tradition steadily departed from the British tradition of private prosecutions. I think the Woolhandler and Nelson article.
Okay, so
yeah.
I guess then from there, does it matter that here we're not talking about a person that's going to be prosecuting crimes and you're exercising their own discretion to prosecute, to select which ones to prosecute? But here, under the terms of the contract, the final decision to proceed to have seized assets declared forfeit is made by the publicly accountable prosecuting attorney and not Mr. Taylor. Does that have any impact in the analysis?
No. Go ahead. I was going to say no, and for a couple of reasons. First, I don't think there's any supportable line between kind of civil prosecutions.
But here, the person that has the final say does not have any financial incentive in bringing a forfeiture claim, right?
Yeah, I take the point.
And so in that way, isn't this very different from the historical instances that both sides kind of talk about?
No, I don't think so. And I do want to make one factual point very clear, because the contract certainly says what it says. But if you look at the stipulations that are in this separate appendix, the defendant stipulated clearly that, in fact, the prosecutor's offices have nothing to do with actually deciding whether prosecutions are brought.
I thought there was a county or two where there was more communication between the prosecutor's office and the attorney.
Yeah, so I believe in Henry County, and I may be misstating the county, a non-attorney investigator would forward the potential cases to Mr. Taylor, but in every other county, it's entirely hands-off.
But what is, under Indiana law, what is the potential authority of the prosecutor to intervene or to supervise closely?
So I don't think Indiana law says anything one way or the other about that, Judge Ripple. What we know from the record here, however, is that, one, the contracts themselves reserve to Mr. Taylor unilateral authority to decide whether to settle or proceed with the cases. And to the extent the contracts do reserve some authority to his clients, the parties have stipulated, and the deposition testimony supports, that in fact his clients take a very hands-off role. The Hancock County prosecutor, for example, testified that he, quote, takes great pains not to supervise Mr. Taylor's work.
Problem may be that the prosecutors are lying down on the job.
That very well may be correct, Your Honor. But at base, what we're challenging here is not just the statute, but also Mr. Taylor's contingency fee arrangement. And under the contingency fee arrangement that they've stipulated they have, Mr. Taylor exercises vast and unsupervised discretion over how to bring and whether to bring these cases.
Suppose a person resists having property forfeited, says, I'm not going to settle. Do they have, tell me about the judicial recourse they have.
Sure. So a property owner in a civil forfeiture case they're basically a defendant in any kind of civil enforcement proceeding. They can take the case to trial. But I do think it's worth noting, Judge Ripple, that unlike in a criminal case, there are a bunch of disadvantages that civil forfeiture defendants have. For example, they're not entitled to appointed counsel. The standard of proof is lower. And here you have the very prosecutor who's bringing the case standing to make money if he wins and not if he loses. And
Are there any procedural advantages that Mr. Taylor would have that other civil litigants would not have? In other words, there are cases that talk about whether or not a particular attorney has the power of the machinery of the state, right? Subpoena power outside of the civil context. Does Indiana provide any sort of extra authority to Mr. Taylor than what other civil litigants would have?
I mean, I can point you to a couple of examples, Judge Lee. For example, he has the power to seek ex parte seizures of property. That's under the Section 3424(1)(2), I believe. And we point out in our opening brief that he certainly has, police investigatory resources at his disposal. But I think the more fundamental point is that he has...
What does that mean?
Oh, so sure. So, for example, it's in one of our footnotes in our opening brief, but we pointed out that, he kind of works cooperatively with police, and they're searching people's cell phones and providing him information that they wouldn't get but for the fact that they're police officers. But if I may, I do want to be responsive to your question, because I think the most fundamental point is that Mr. Taylor has precisely the same prosecutorial function and precisely the same power as any full-time sworn deputy prosecutor who's bringing these forfeiture cases in any of the many counties in Indiana that do not rely on contingency fee prosecutors. His prosecutorial function is the same as any other sworn prosecutor in Indiana or elsewhere who brings these kinds of cases.
What's the purpose of the forfeiture system?
Ultimately, it has a variety of purposes, Chief Judge Sykes. Courts have described it as both punitive and serving somewhat ill-defined remedial purposes. But I don't understand there to be any dispute that this civil forfeiture regime falls squarely on the sovereign criminal justice side of the spectrum when it comes to the kind of litigation that the government can be involved in.
Right. Well, the reason for my question is you've argued that the due process principle here is that prosecutors serve the public interest.
Yes.
And the due process clause requires somewhere in between that there not be a conflict between the public interest and the prosecutor's personal interest pursuant to some sort of a test that we're trying to get our arms around in this case. So we need to isolate what the public interests are in this forfeiture system and whether there's a misalignment, a conflict between the prosecutor's personal interests and the public interests, and I kind of see the interests as being aligned, but maybe you can persuade me otherwise.
Well, I hope to, Chief Judge Sykes, because if you look at Mr. Taylor's deposition, even he acknowledged that the government's mission in forfeiture cases is to achieve what he described as big J justice. And by that, I understand him to mean the same kind of, justice-seeking mission that we see engraved on the, foyer of the U.S. Department of Justice in D.C.
But in concrete terms, what
Certainly.
is the policy reason
Certainly, Your
for
Honor.
a forfeiture system like this? What is the government's objective?
Certainly. So ultimately, it is to punish people who have either violated the law or let their property be used in violations of the law. Property cannot be forfeited under the civil forfeiture statute unless Mr. Taylor proves by a preponderance of the evidence that a violation of Indiana state criminal law has taken place. As the district court acknowledged, for all the flaws that we see in that opinion, the district court acknowledged that this falls squarely on the criminal side of the spectrum here. And so I think for purposes of identifying what the public interest is, I think it's largely interchangeable with the public interest that an assistant U.S. attorney has to serve in prosecuting a felony case or a state prosecutor serves in bringing a capital case. The goal is not to make money for that particular prosecutor. The goal is to achieve a just result. And I don't understand there to be a serious argument from the defendants that if, in fact, Marshall's standard is what we say it is, that Mr. Taylor's contingency fee arrangement cannot stand under that standard.
Well, the Indiana Supreme Court has identified other objectives of the forfeiture system beyond punishing or disincentivizing cooperation with criminals via the use of property,
I think that's right.
as articulated in the Cantor and other cases.
Sure, yeah, I think Cantor refers to remedial purposes, but I think the same could be said of any kind of criminal law enforcement, right? Like the purpose of putting someone in prison is not purely punitive, purely deterrent. It also serves to incapacitate people and remediate. And so I don't think that there's any material difference between the interest that the government has to serve in bringing civil forfeiture cases versus the interest that the government has to serve in bringing criminal cases. And that, I think, in large part, is why when you have forfeiture prosecutors facing damages liability for violating people's rights, they typically successfully invoke the kind of absolute prosecutorial immunity that attaches only because there's this concern that any kind of financial considerations might skew the public trust.
So in that rationale, if we had to choose between the Matthews interest balancing test and the Medina test, you would support the Medina test?
I suppose that's right, Judge Lee. I mean, I think ultimately it kind of both of those would lead to the same result. If you look, for example, at...
No, I understand, but you have to choose one.
Sure. I mean, I think that we would win under Matthews, and I would point you to retired Justice White's reasoning in the Ninth Circuit case, where he basically said that a biased proceeding is one that is necessarily not sufficient under the due process
You
clause.
said you would go under Matthews? I thought you just spent 5 minutes talking about how criminal forfeitures are actually criminal in nature, which would lead us to Medina.
I think that's right, and I'm not trying to duck the question, but yes, I mean, I think if we were applying Medina, we absolutely would win here too, and it would basically support the standard that we say Marshall articulates. Because ultimately, and I say I'm over my time, but if I can answer your question, ultimately, I think what the historical record shows is that at least starting in the 19th century, anytime anybody spent more than a couple of minutes thinking about contingency fee prosecutions, the overwhelming consensus is, in the words of one federal judge, that this was an unspeakable evil and a disgrace to the republic. And so you have the Kentucky High Court in 1864 saying a contingent fee dependent on conviction ought never to be permitted to stimulate assistant counsel. You have the Wisconsin Supreme Court in 1888. You have the New Mexico Supreme Court drawing on these same principles in 1920 to describe it as abhorrent to the sense of justice. So I do think whether we're talking about Marshall articulating its own standard, which I think is the only way to read the result there, or whether we're talking about Medina, ultimately the contingency fee arrangement that we have here is far on the side of the unconstitutional end of the compensation spectrum.
One last question. I know we're way over time, but your historical argument really depends on situating the historical analysis at the time of the ratification of the 14th Amendment rather than during the founding era, because it was slightly before and at that time, and certainly after that time, that these new norms came into play in our legal history and tradition, not at the founding.
Well, so I don't know if I would agree with that, Chief Judge Sykes. If you look at the Woolhandler and Nelson article, which we have in our reply brief, I think they make a persuasive historical case that even before the founding, the American criminal justice tradition was moving away from that tradition of private prosecution. And they also point out that, the district court pointed to the Adams versus Wood case, I think, which was from Chief Justice Marshall. And Professors Woolhandler and Nelson actually point out that I think folks since then have overread that decision as suggesting that kind of qui tam was rampant under all kinds of penal statutes at the time. So I think as a historical matter, that's not necessarily correct. But certainly by the time we get to 1830s, 40s, 60s, 70s, the overwhelming consensus is that this is absolutely corrosive to the criminal justice system. And I'll just note parenthetically that if we're looking at the kind of history the court was doing in Toomey, or if we look at Justice Alito's Bandita analysis in his separate opinion in Nelson versus Colorado, they don't stop the clock at 1791, or for that matter, even at 1868. Like, they're looking at cases up through the 1890s. And likewise here, if you look at the overarching course of history in the 18th and 19th centuries, I think what you'll see is that there's an overwhelming consensus, that this is a system that pits the interests of the prosecutor in making money against the government's interest in ensuring that justice is done to its citizens.
Thank you.
Okay, thank you.
Mr. Barta.
May it please the court. At the time the Fifth and 14th Amendments were adopted, and for decades afterwards, it was common for the governments to reward interested parties for uncovering and successfully prosecuting wrongs. Embracing Sparger-Withers' position would require rejecting the very historical tradition that the Supreme Court regards as its primary guide to due process, and require this court to part ways with other appellate courts upholding contingency fees for attorneys retained by the government. But I don't think the court actually has to get to the merits in this case due to the mootness issue, and I'll start there before talking more about the due process. Sparger-Withers' claims for prospective relief became moot when the only forfeiture action involving her property was dismissed 6 days after this case was filed. And there's no reasonable expectation that the previously dismissed forfeiture action could be refiled because it would be time-barred. Under Indiana law, a forfeiture action has to be filed within 90 days of the seizure or 21 days of a property owner demanding return of the property, whichever comes first. And since the forfeiture here occurred in January 2021, any refiled forfeiture action would be time-barred under the plain text of the law.
Probability of refiling is not an issue under the inherently transitory doctrine?
Correct, Your Honor. And so I think turning there, the inherently transitory doctrine is fundamentally an equitable doctrine designed to allow classes to be certified in cases where it just couldn't otherwise happen. And I think this court has made clear in Trotter and Banks that the doctrine is not available when a plaintiff makes a strategic call to delay bringing suit, and that's exactly what happened here. Sparger-Withers could have filed this federal action at any point after the forfeiture case was filed on February 1st, 2021. But she waited until November 2021, after she was acquitted in state court for the predicate crime, to file this forfeiture action. That means there is and I think that 282-day period pales in comparison to the 70-day period in Banks, 70-day period in Trotter, or 112-day period in Banks, where this court held that the inherently transitory doctrine was not available when the litigant waited to bring suit.
I thought in Olson, the focus was more on whether or not the plaintiff had reason to know that the claim might become moot, as opposed to whether there was a strategic decision to wait to file. And certainly that was the case with regard to the named plaintiff in Olson. And it seems that here too, Ms. Sparger-Withers had no idea that Mr. Taylor would dismiss her case without prejudice when he so conveniently did right after she filed suit and filed the motion for class certification. So why wouldn't that fall squarely within Olson?
So, Your Honor, I think at page 252, Olson set aside the situation in which a litigant waits to bring suit. But I think the other key piece in analyzing Sparger-Withers' case is that she certainly knew the forfeiture action would stick around for a while after it was filed, because as she noted in a motion she filed in November 2021 in state court, the state forfeiture action was effectively stayed in February 2021 pending resolution of the criminal trial, which happened in November. And so, I think it's not surprising that after she was acquitted in the criminal trial, there was a decision made that the forfeiture action simply was not worth pursuing at that point in front of the same judge who had just said she's not guilty of drug dealing. But I think for the purposes of determining whether it's appropriate to apply an equitable doctrine, that the court should not be in the position of rewarding litigants who make a strategic call to delay filing suit.
What about, on the flip side, should we award defendants for strategically dismissing cases in order to circumvent judicial review of actions that they're taking with regard to other members of the purported class?
Well, no, Your Honor. I think that's exactly what the picking off doctrine gets at, is manufactured mootness. But the testimony here was that the forfeiture action was not dismissed to moot the federal case. Rather, it was because she was acquitted of the predicate crime in state court, which just changed the merits of the analysis. And I think for the purposes of the inherently transitory doctrine, which is what the district court went with rather than picking off, is that we also have to bear in mind that it asks whether any potential plaintiff in the class could bring the case. And as noted at page 46 of our brief, there are certainly cases in which other members of the class could file this due process claim because forfeiture actions can last for months or years, sometimes because they are stayed at the property owner's request pending the outcome of criminal proceedings. But unless there's further questions of the mootness, I'll turn to the due process issue. When we approach the due process clause, it's important to remember that the states presumptively have the power to decide how their law is carried out. So Sparger-Withers has to show not just that Indiana could have developed a better or more popular system of retaining private counsel to assist with forfeitures, but that the system it adopted would have been rejected by those who framed the Fifth and 14th Amendment as contrary to settled principles of justice. And she can't either as a matter of history or of precedent. So on the history side, there are sort of four distinct lines of history that show that it was common at the time the Fifth and 14th Amendments were adopted to reward persons for successfully uncovering and prosecuting wrongs. Those are, we first have the long-standing tradition of private prosecutions in which victims of a crime could hire their own attorneys to file criminal charges against people, and a tradition that remained in common use not only from the founding but into the 20th century. I think in the Cardenas article it says in 1951 it was still very common to have private prosecutions, and at last count I think today there's 20 states that still permit private prosecutions, from Massachusetts to Ohio to Washington. The second strand we have is the payment of conviction fees. In the 19th century, about 2/3 of the states and the federal government paid prosecutors' fees for successfully winning criminal cases. Now, in the late 19th century, that started to fall out of favor for policy reasons as Congress decided there were better ways to generate public support for new laws that were less popular, but it certainly wasn't a settled tradition to forbid them. Third, we have the moiety or bounty system, in which federal officials were paid a share of goods that they uncovered, or paid a share of fraudulently invoiced goods that they uncovered at customs houses. A tradition, again, that existed for about the first 90 years of this country's existence. And then finally, we have key TAM actions, still in use today, in which the private parties who are pursuing these actions in the name of the government are rewarded for success. Now, in terms of the question earlier, I don't think it matters what historical period we're looking at, whether it's the 5th or 14th Amendment's time of adoption, because these practices were still in widespread use at both times. And as the Supreme Court reminded us in Montana versus Ingelhoff, a plaintiff challenging a procedure as contrary to the Due Process Clause has to show more than just that the states or the federal government were moving away from the practice at the time the 14th Amendment was adopted. They have to show there is a settled tradition rejecting it. And that, whatever else, that it doesn't exist here. Turning to the precedent side, we simply don't read Marshall as establishing with particularity any standard regarding what incentives are appropriate or not appropriate for advocates. All that is said is that whatever the standard we apply, the incentives here are too remote and insubstantial to raise a due process problem, which I think then brings us exactly back to history as the Supreme Court, in order to understand what, if any, due process limits there are.
What are we to make of the court's statement at the end of Marshall as follows? But in light of the factors discussed above, it is clear that this possibility is too remote to violate the constraints applicable to the financial or personal interests of the officials charged with prosecutorial or plaintiff-like functions.
Yes,
So that's sort of like as a, I don't know, holding light or something. I'm not sure what it is, but we have to make some sense of it because the court was clearly saying something, and even if it's dicta, we have to pay attention to what the court says.
Yeah, so I think the best way to read is the court was proceeding on the assumption that there is some kind of standard, because as it noted at the end of Section 2A, the government did not take the position in that case there was no due process standard applicable to advocates, and so it was just proceeding on the assumption there was some kind of standard, and it said, whatever the standard we apply, there's no problem. And I think the citation to the realistic appraisal language that Spargo Withers likes to talk about in a brief underscores that. That language comes from Withrow versus Larkin, a case about the due process standards for administrative adjudicators, which the regional administrator was here. The regional administrator certainly had some advocacy functions, but also was in the business of assessing penalties. And Withrow said that even if we were to, and so that was a case about the due process standards for judges, and I think the citation just shows that the Supreme Court was saying in Marshall, even if we were to apply the strictest possible standard, there is no due process problem.
But the court said in a footnote it wasn't doing that.
Well,
Footnote 14.
yes, Your Honor. I think I tend to read that footnote as suggesting that the court was just saying we have some more leeway, as it did in Withrow, where it said that the standards for Article 3 judges aren't the same for administrative adjudicators, and so it was sort of in that middle ground between Article 3 judges and advocates, and I think that's the best way to make sense of the decision. But even if we were to accept the premise that there is some standard in Marshall, I don't think that it changes the analysis in looking at the arrangements here for a couple of reasons. First, it is important to remember that the incentive structure here actually aligns the advocate's incentives with the state's. The advocate here is retained by the state. His client is the state. He has an ethical obligation to pursue the state's interest, and the mere fact that he's paid on contingency doesn't pit his interest against his client's any more than in any other civil case in which an advocate is retained on contingency.
That depends on what the state's interests are.
Well, I agreed, Your Honor, and I think that's, if we're looking at what those means in concrete terms, we know by the enactment of the statute that the legislature has made the determination it is in the state's interest to seek the forfeiture of property where it's an instrumentality or proceeds of a crime. And the other important fact here is we have elected public prosecutors who have made the determination that it's in the state's interest to hire a private attorney on contingency to pursue these forfeitures. And at any time, if they decide that it's no longer in the state's interest, they can stop referring cases, they can terminate the agreement, or they can make the decision that an individual property owner should not have a piece of property declared forfeit.
The Indiana Supreme Court, in the Cantor case, said there's also a taxation offset interest here, as well as a deterrent interest in deterring by creating an economic disincentive persons from engaging in future illegal acts and permitting their property to be used to engage in future illegal acts. But there's also a significant taxation minimization purpose in play here, which is probably more closely aligned with the personal financial incentive that the statutory scheme creates for Mr. Taylor. There's at least a potential for divergence in the criminal punitive function, a conflict of interest, because the prosecutor would be incentivized to increase his own pay by pursuing forfeitures even when there's not a link to the congressional or to the commission of the crime.
Well, respectfully, Honor, I think actually the opposite is true. So to be clear, this is a civil action with a private attorney, not a prosecutor. But one of the things that a contingency fee arrangement does is it actually creates an incentive to vet the cases well before filing them to make sure that these are actually meritorious cases. An incentive someone may not have if they're just being paid by the hour or on a fixed fee. And I think, as this court has said in other contexts, contingency fees actually serve as a monitoring device, making sure an attorney is spending appropriate amounts of time on different cases and making sure they're meritorious. And so I think that it actually serves to align their interest here. And I think the final consideration is it's hard to see if this is unconstitutional, why other arrangements are not. States not only hire private attorneys to pursue a wide variety of actions, but also public prosecutors have to stand for elections. They face pressures at the ballot box. Their subordinates face pressures to perform well to keep their jobs. If there are no further questions.
Thank you. Mr. Gedge, you had used all your time, but you can have some additional time in rebuttal if you have something to say in response to your colleague.
Thank you.
So are we going to extend Caperton to elected prosecutors?
Well, no, I don't think so, Your Honor. And in fact, in the Louis Vuitton case, what the court said in describing Marshall was that we, said that, this situation in Marshall was okay, even though it might be intolerable in the context of a judge. So the court clearly was identifying two different strands of standards from Marshall. And I do, if I may, want to take a quick swing at trying to persuade you that Marshall actually did articulate some kind of standard. Because it is passing strange, I think it would be highly uncommon for the Supreme Court to say, well, there might or might not be some kind of standard in this case or controversy. We're not going to decide, but we're going to reverse on the merits. I just don't think that's how the Supreme Court resolves controversies. And I understood my friend Mr. Barta to acknowledge, I think, that Marshall stands for, I think his words were, some kind of standard.
Right, and that conflicts with the position that it's all based on history.
Well, I think that's precisely right, and I won't belabor the fact that I think history absolutely supports Marshall's standard, but if we're all sharing common ground that Marshall, in fact, articulates some kind of standard, I think the question becomes, well, why don't we look at the applying law to facts section in Marshall as the most instructive data point for determining what that standard is? And here, the court in Marshall, I believe 4 times, emphasized that no individual prosecutor stood to profit economically from vigorous enforcement. We've cited them in the brief. I think there's 4, but I may be off by 1 or 2. And here, even the district court acknowledged that it is, quote, hard to imagine a financial interest more direct than the kind of financial interest we have here. So I think if Marshall means anything like what we say it means, and we submit that it does, I don't think there's any serious argument that Mr. Taylor's contingency fee arrangement violates it. Thank you.
Thank you very much. Our thanks to all counsel. The case is taken under advisement. We'll move to our 4th case this morning. And that is Kristen Dent versus Charles Schwab and Company. Mr. Emery.
Thank you, Your Honor. I'll try to make this brief, but that doesn't always work out.
I'm sorry, I didn't hear you. The microphones don't amplify, they just record, so you'll have to speak up.
Okay, thank you. I'm glad to be here, and I hope you'll understand that it's a one-issue case. We're not talking about this long discussion that we have, because I think it's not only a simple issue, it's already been resolved. This is a case with one issue. The only issue is whether the 90-day rule in discrimination cases requires a ban on proceeding after 90 days. The statute provides that there's a 90-day limit, but nowhere is there any indication that the statute intended for it to be hard and fast like some other rules. If you file a complaint, which we did in last year, 2023, at that time, the rule in this district, this court, or other circuit courts was that if you missed it by 1 day, you were out the door. The Supreme Court in Beckler PC versus Commissioner changed that rule. Unless a rule specifically provides that 90 days is it, you can't refile it or anything. You're done. That's what happened to Kristen the complaint was filed during the July 4th wedge of July. And for some reason, it didn't go through, the complaint didn't. The fee-
Actually, it wasn't filed. The process wasn't
That's what it
completed.
says, but
The
in my-
process has an additional step that was not taken after the payment of the filing fee. So the filing didn't occur until July 10th, I guess it is. And the question here is not whether the 90-day deadline is jurisdictional. Everyone agrees it's not jurisdictional. Equitable tolling is available here. The only question is whether this error in filing qualifies for equitable tolling.
That's correct. That's what
So-
we're asking the court to point out and direct the lower court to at least take the evidence to see if equitable tolling applies.
Well, that was the opportunity that you had already below, and it failed. So that's why we're here, to review whether there's anything in the record below to support equitable tolling, or whether the district court made the right call
Well, it's-
on judgment on the pleadings that equitable tolling wasn't satisfied here.
well, I have to disagree, but I'll accept your opinion. In any case, that brings us here, and I'm asking the court to order the lower court to reinvestigate it, take more evidence before it makes a ruling. That's all I can say. It was my error, and I said that to the court, that Kristen Dent shouldn't be punished for what somebody else did. And 5 days is not much during a holiday season. That there ought to have a time or a chance to explain to the lower court. Right now, that absolute rule is out the door because of Beckler. The United States Supreme Court in Beckler said equitable tolling should be available under the circumstances. And that's what I'm asking this court to do, is order the lower court to hold a hearing and let's hear all the evidence, not just that much. The only evidence in this case is the fact that it was filed 5 days late. I would submit that it was actually filed, but something failed in the system, and it wasn't caught until the clerk's return from the holiday vacation. And when it was filed, it was the 4th. If I'd known, I could have done it on the 5th. Thank you.
Thank you. Ms. Pactor.
Good morning, and may it please the court. My name is Ellen Pachter, and I'm here for defendant appellee Charles Schwab. As Mr. Emery just stated, there's only one issue in this appeal, which is whether the district court erred by granting Charles Schwab's motion for judgment on the pleadings and dismissing Ms. Dent's complaint as time barred. The district court did not err, and its judgment should be affirmed. This is relatively a straightforward appeal today. As Chief Judge Sykes just pointed out, appellant's argument regarding Beckler versus Commissioner of Internal Revenue was not addressed to the district court, and as this court well knows, a litigant cannot raise an entirely new argument on appeal. Therefore, that element of Ms. Dent's argument is waived here. Looking toward the district court's order, in which the district court found that Ms. Dent did not meet her burden to establish that she was entitled to equitable tolling, the district court properly found that she was not. There are two elements to establish equitable tolling, And the district court focused on the first one, which is whether the party pursued her rights diligently. And I think is outlined pretty well in our Appellee's brief. The Southern District of Indiana provides significant guidance on the proper way to successfully complete a filing and initiate that lawsuit. And I'll just draw the court's attention to what I think is the most important and key step here, which is the Southern District of Indiana's electronic civil case opening procedures, which are step-by-step instructions on how to open a new civil case. And one of the instructions says that after accepting the filing fee payment, the pay.gov website will return the filer to CM-ECF for completion of the document filing process. The instructions also include a warning in eye-catching bold red letters that warn the filer that failure to complete the filing process at this point in the transaction will result in the payment of a filing fee without having properly filed the case initiating documents. I think this is a key point, and if a person filing a complaint in the Southern District of Indiana is not following this instruction, we cannot say that the party was pursuing their rights diligently. Also of note, the Southern District of Indiana provides several steps to address any potential errors, such as creating a record of an error through a screenshot, contacting the clerk's office, or filing a declaration that the party was unable to file in a timely manner due to technical difficulties. None of those actions were taken here, and with that, the district court again properly determined that the party, Ms. Stent, did not pursue her rights diligently. So with that in mind, Schwab respectfully requests the court affirm the district court's dismissal of Ms. Stent's complaint, and unless the court has any questions, we thank you for your time.
Thank you. Anything further, Mr. Emery? All right, thank you very much. Our thanks to both counsel. The case will be taken under advisement. Our next case for argument this morning is United States against Frederick Brewer.
Good morning, Your Honors. May it please the court, Edward J. Hunt, appearing on behalf of Frederick Brewer. Let me just begin by saying this case took strange and weird and bizarre to a new level. And let me explain by that. As to the distribution counts, the person that did the actual, or rather, as to the distribution controlled by counts, the person that actually engaged in the controlled buys was never called as a witness. A person that was waiting out in a car on two instances in which the controlled buy occurred at the Brewer residence, and another instance, the same person, Maisie Chang, was waiting out in a car, I believe at a different location, her home, but not at the Brewer residence. The person that was doing the exchange was a person named Heather Laguerre. That person was never called as a witness. So in terms of even identification, the identification of the defendant was not completed by Maisie Chang, who was the person that supposedly got the drugs eventually. The identification was done by police officers from a distance. But then it got even stranger, Your Honors. At that moment, in February 2023, after about 2 or 3 days of trial, when the jury came back guilty as to the conspiracy and guilty as to the possession with intent to deliver, and guilty as to the 3 controlled buys, the jury is asked 2 very important questions as to the conspiracy and also as to the possession with intent to deliver. Is Brewer, in effect, to be held responsible for this offense involving at least 400 grams? They answer no. Well, then the default question comes up pretty quickly. Is Brewer responsible, or has rather the government proved, I should rephrase that, has the government proved beyond a reasonable doubt that Brewer is responsible for at least 40 grams? The answer is no. So we have a conspiracy. And by the way, they answered the same way for the possession with intent to deliver charge. No, the government had failed to prove beyond a reasonable doubt that the possession with intent to deliver offense involved 400 grams. And again, answered no, had the government failed to prove beyond, or had the government proved beyond a reasonable doubt that the offense involved at least 40 grams. So we hop from that to a really, for lack of a better phrase, deep dive into the type of evidence that I'm asking, imploring this court to take a look at as a second look, as a constitutional backstop, knowing full well that this is a deferential standard, that the government, the evidence is viewed in the light most favorable to the government. And that the standard also involves this concept of the rational trier of fact, that in other words, appellate courts are not a do-over court. They're not there to place themselves in the place of the jury. They're just there to take a look at the evidence, see if there's error, and also assess if that deferential standard, which favors the government, is met. The reason why I have concerns, and the reason why, most importantly, Mr. Brewer has concerns about this case, starts not only with the concept of whether a conspiracy was proved at all. Now, you might say, well, wait a minute, Mr. Hunt, there was a lot of talk here about text messages and drug amounts and drugs and people, your client posting on Facebook, I got perks, or what's up with perks? But here's where the deep dive component comes in. If you pay attention to the text exchanges between Azogio, who is the king of suppliers, supposedly, he's the person that would be in Arizona supplying to Don James, who, by the way, parenthetically, maybe not parenthetically, emphatically, Don James, the jury had no problem finding him responsible for 400 grams, answering that question, as to both count 1 and as to both count 2. So just concentrating on Azogio. Azogio is supposedly, under the government's theory, a supplier. He's engaging in these conversations with Don James. At no time in those conversations is Don James saying something that would take this away from the concept of buyer-seller. In other words, he's not saying, look, I'm in business with my brother. We got to hustle here. I got to come up with the money. Anything like that. It's just conversations as if Don James is operating as a sole proprietorship. And as this court is amply aware, because the court has ruled on several occasions, not only in U.S. versus Johnson that I cite, but also in the United States versus Vizcarra-Milan, when you're analyzing under a totality of circumstances, when you're applying the rules of thumb that help distinguish a conspiracy from a normal buyer-seller relationship, you're going to take a look at sales on credit or consignment, an agreement to look to for other customers, a payment of commission on sales, an indication that one party advised the other on the conduct of the other's business, or an agreement to warn of future threats to each other's business stemming from competitors or law enforcement authorities. Now, my argument is that these factors aren't found in this particular case. There is another interesting set of exchanges on the phone, or rather on text message, with Don James and a local Green Bay person named Trell, who he's dealing with, and another local Green Bay person named Muggeries, in which they're having drug talk. Again, just as in Geo conversations, my client's name isn't mentioned. There isn't a reference like, hey, my brother's going to help out. There is this kind of coincidental, different track that my client is, the evidence against my client is employed to show that he is a member of a conspiracy. And that is that he has a conversation with a character by text named Black Doing Numbers. And when he's having this conversation with Black Doing Numbers, it's alleged, and the evidence supports these text messages, that he's saying, I'm going to pick up my bro's got a load, but there's no evidence that my client picked up anybody, which boils down to a kind of a common thread that flows through this. Yes, circumstantial evidence is as powerful as direct evidence. But this is taking circumstantial evidence to a whole different degree. This court, or rather other courts, I should say, have said this about circumstantial evidence. The Newman versus Metrish decision from the Sixth Circuit in the United States versus Cartwright from the Third Circuit, although circumstantial evidence alone can support a conviction, there are times when it amounts to only reasonable speculation and not sufficient evidence. Here's my parting shot. I see the yellow light is on. I think this is too much speculation, with all due respect.
Counsel, is there any evidence in the record that James and your client, of an exchange of money between James and your client on the sale and purchase of drugs?
No, I don't recall that. I don't recall any transfer of money from James to my client.
So that kind of, doesn't that cut against your argument that there's a buyer-seller relationship between these two people?
Pardon me?
Doesn't that create a problem to your buyer-seller relationship argument?
No, Judge, and I think I know where you're coming. You're focusing on aiding and abetting, that scenario supports he's aiding and abetting, he's not getting any money for it. I think, given the other evidence in the case, these controlled buys and other instances, they seem to support that my client is someone independent from him, that he's doing his own business, that he receives drugs from him, and I think that's the most benign way to look at it.
Thank you.
All right. Thank you, Your Honor.
Thank you. Mr. Funnell.
Good morning. May it please the court. My name is Tim Funnell. I'm representing the government in this case. Mr. Brewer was found guilty of 5 different counts. That's 3 distribution, 1 possession with intent to distribute, and 1 conspiracy count, all related to the trafficking of fentanyl. He has to argue here that there's insufficient evidence to support the verdicts on all of those counts. As the briefing states, and as counsel acknowledges today, the evidence has to be viewed most favorably to the government. He faces what this court has called a nearly insurmountable burden, and the court can only reverse when the record contains no evidence upon which a rational jury could find Mr. Brewer guilty. Respectfully, the government sees nothing out of the ordinary in the way that the evidence was presented in this case with regard to any component, and especially with the controlled buys. The fact that the middler did not testify is not unusual. The middler was somebody who the informant that was working with the drug task force knew had contact directly with Mr. Brewer. So we have evidence in the record of the text message exchanges between the middler and Mr. Brewer that preceded each of the controlled buys. The middler was not a federal target. She was not somebody who was cooperating with the drug task force. The informant was. And so from an evidentiary standpoint, since we have control buys, meaning audio surveillance, physical surveillance, video surveillance, we have searches of the informant before and after, we have the controlled money that's being recorded, all of those things essentially make it unnecessary for the government to bring the middler in to testify. We didn't do that. We didn't need to do that, and the jury certainly had ample evidence upon which to find the defendant, Mr. Brewer, was the party that was involved in those control buys. Just to take the final control buy as an example, the first two occurred at the residence that Mr. James and Mr. Brewer shared on University Avenue. The third control buy, however, took place at the residence on Ashland Avenue. That's where the middler resided. Well, we have actual video of Mr. Brewer driving his Chevy Impala the Sebring, the Chrysler Sebring, to and from, arriving there and leaving the scene of the control buys. The control buys were January 21st, January 31st, and February 7th, all a week apart in 2022. They occurred just within a couple weeks of this trip that Mr. James, the defendant's brother, took to Arizona, where he was engaging in text messages and showing videos to people back in Green Bay of what he called boats of fentanyl pills. A boat is 1,000 fentanyl pills, and we're talking about the small blue imitation Percocets. He sent a video of 19 of these bags of boats, and that transaction, that trip took place January 6th to January 9th. We have the defendant, as Mr. Hunt acknowledged, Mr. Brewer is telling a customer in Green Bay, hey, brother Don James is going to hop off a plane tonight. This is on January 9th. So as Mr. Brewer is engaging with this potential customer here in Green Bay, he's telling the customer, hey, we can still do business, but brother is hopping off a plane tonight. I got to make sure he gets in the house with that load. Mr. Brewer does not mention any specific numbers for the load, and perhaps this gets into why we have the jury coming back the way that it did on the special verdict questions, the 400 grams and the 40 grams. Because while you have Mr. James discussing specific amounts in his text messages with the person in Arizona, with a couple people in Green Bay, you do not have Mr. Brewer engaging in those types of specific wholesale numbers, because as Mr. James says in one of his text messages, he says, I wholesale. And as the district court emphasized in its denial of the Rule 29 motion, you essentially have Mr. James and Mr. Brewer working together in this shared enterprise where Mr. James is working at the wholesale level, getting volume, and Mr. Brewer is engaging at the retail level, dishing these things out.
What do you make of the absence of any mention of payment?
I think that's an important point, because there really didn't need to be discussion between Mr. James and Mr. Brewer about payment, because they were clearly working together. There was no need to negotiate numbers between the two, because that's not where the negotiation was occurring. It was occurring at the wholesale level with Mr. James. We do have one instance, however, where the money from I believe it was the January 31st control buy, the recorded buy money, $140 of that buy money ended up in the potential bail money for Mr. James. And the way that money would have been routed to Mr. James's sister would have been that it went from the informant from Drug Task Force to the informant on January 31st. Then it would have gone briefly to the middler. Then it would have gone to Mr. Brewer in exchange for the pills. And fast forward from that January 31st control buy to February 12th, and Mr. James is now under arrest. Mr. Brewer had been arrested on the 8th or 9th, I believe. Mr. James is now under arrest, and he's telling his sister that he needs some bail money. He tells her to get $5,000 bail money for him. Well, in that $5,000 bail money, lo and behold, they find $140 in the buy money that Mr. Brewer had been a part of that controlled transaction back on January 31st.
Could I ask you to address, if you would, this sentencing issue with respect to conduct for which the accused was arguably found not guilty, or with respect to the amount, and then the district judge decided to consider it. At midnight tonight, we have a new guideline coming into effect. How does that in effect say that from going forward at least, that district judges can't do this? Does that new guideline have any effect on our case?
It does not, Your Honor. The Sentencing Commission, to my knowledge, has not made that guideline retroactive, at least to this point. If they do make it retroactive, that could potentially form the basis for a 3582C motion for Mr. Brewer. At this point, however, since there is no such retroactivity, there would be nothing for this court to do. I know that there's sort of a similar situation in a different case at the court, the Claiborne case, and it's not cited, but since it was raised here, where if it was a situation where we knew right here today that it had been made retroactive, then perhaps the government would consider joining in such a motion to bring it back before the court. And that gets to the second part of your question, which is this the type of case where that new guideline could play a role? And I think the answer is contained within the language of the guideline in two different places. Number one, it says that when the underlying conduct that is the acquitted conduct, if it either forms the basis in whole or in part of the instant offense of conviction, then the acquitted conduct guideline does not require it to be disregarded. However, it does say that the district court is in the best position or the ideal position to make that sort of determination. So just to play this out, if we get to the point that there is a retroactive, a 3582C situation here with Mr. Brewer, Judge Griesbach would be well suited to then take that matter up if a motion is brought and determine whether the conduct, the 400-gram threshold, the 40-gram threshold, the money, or excuse me, the pills that were coming back from Arizona, the 19,000 votes, the 30,000 discussion, the 30,000 pills, all of those things, he would be well suited to make a determination whether that is part, wholly or in part, of the instant offensive conviction.
And what happens to the Watts case, the Supreme Court case that basically said the government or the district judge could consider acquitted conduct?
Well, I think there would be two things that come out of that, Your Honor. One is just as a matter of due process and the basis of the Watts decision, I think the court still could consider it because when we're dealing with the new guideline, that is a guideline calculation exclusively. And so I don't think there's anything in the guideline itself or in any other case law that would say the judge is, even though he's now bound by this new guideline, that he can't consider it under the 3553A factors. Sort of similar to the death results enhancement for drug cases, where we see those in fentanyl cases, where I believe this court has said that the death enhancement, it has to be part of the instant offensive conviction to be part of the guideline calculation, but it can still be part of the 3553A determination. And I see I'm out of time. We would ask you to affirm. Thank you.
Thank you.
Thank you. Mr. Hunt, I don't think you had time left over. You had a little bit of time left. I'll give you some extra time.
I turned 70 this morning, and
Happy
I want to
birthday.
thank you. I grew up in the city of Chicago on the south side, in the back of the yards neighborhood, and it's been a rare treat to come down here. Thank you all.
Thank
Bye.
you.
And please do Mr. Brewer a favor. Okay.
Happy birthday.
Thank you.
All right, thanks to both counsel. The case is taken under advisement. Our last case for argument this morning is William Mannery versus Jason Lee. Mr. Overholt.
Good morning. I'm Tony Everholtz, representing Jason Lee. The decision denying qualified immunity to Lieutenant Lee should be reversed because the district court applied the wrong legal standard in assessing the Fourth Amendment question as to when and whether Defendant Lee was entitled to fire his weapon. The district court established quite a few facts in my client's favor that supported the decision that he did not violate the Fourth Amendment. Mr. Mannery was wanted on a felony warrant for aggravated assault with a vehicle, evading arrest, and violating probation. In addition, Lieutenant Lee reasonably believed that Mannery was armed with a handgun, and he had previously threatened to die in a law enforcement encounter with police. In addition, in moments before the shooting occurred, Mannery demonstrated his active resistance to arrest by fleeing police, crashing into a police car, backing into a curb, pulling forward, and then striking another police car. It was at that precise moment that Lieutenant Lee made the split-second decision to fire his weapon. The video shows that, in fact, he fired his gun just a second or two after Mannery struck the second police car. The district court correctly said that the key inquiry in this case was whether a reasonable jury could conclude that Lieutenant Lee believed Mr. Mannery posed an immediate threat to Lieutenant Lee or to others. I don't dispute that. What is disputed in this case, and what the district court was incorrect about, is its myopic focus on the precise moment when Lieutenant Lee fired.
So, Mr. Overholt?
Yes.
Let's assume that the white SUV, when it struck it went to the curb and it struck the car in front of it, right?
Yes.
Let's assume, and I think the video kind of backs up, that it couldn't go anywhere. It was halted. It was blocked. Okay?
Yes.
And by that time, Officer Lee, or Deputy Lee, was off to the side of the car.
Yes.
Right? So if we assume that the car could not move any more further up, right? It could, I guess, move back to the curb. Would you still believe that Officer Mannery had or a reasonable officer in Officer Mannery's shoes would have fired the shots from the side of the car into the car?
Absolutely. And that's exactly the fact that we assumed for purposes of this appeal. We assumed that the car, as the district court found, was stopped and that Lieutenant Lee was off to the side when he fired. The problem with the district court's opinion is that it ignored admonitions from this court in Sanzone versus Gray, in Brummett versus Smith, in Johnson versus Jones. All cases, all of which say a law enforcement officer forced to make a split-second decision must be given the benefit of the doubt and is allowed to take action, in this case to fire a weapon, even though, in this case, Mr. Mannery came to a stop. For example,
But couldn't a reasonable jury or fact finder come to the conclusion that once the car came to a stop, that the car at least no longer posed a serious threat to Officer Lee or those around him?
a jury may conclude that, but the problem is, under the Fourth Amendment, as this court explained in cases like Brummett, an officer cannot process information that quickly. For example,
But with regard to how soon, whether or not there was enough time, because it seemed like, at least from the video, there was some time.
There was a
right?
second or two, yes.
So some time between the time that the officer moved over
Yes.
and then shot. And I take your point that things were happening and that there was a lot going on. But as to whether or not by that time there was enough time that elapsed between the time that the white car had stopped and the shots were fired, whether or not there was sufficient time for a reasonable officer to consider that threat to have been eliminated, isn't that a factual finding that's better left for a jury?
No, for this reason. One, qualified immunity is a question as a matter of law. As this court explained in Brummett.
Well, I realize it's a matter of law, but I'm looking at the predicate facts, right, that would go into that legal analysis.
Well, let's look at the predicate facts. In the predicate facts, we know that Mannery was a felon fleeing on a warrant. We know he had threatened to die.
Let me ask you this then. So let's take a hypothetical situation where I know here the dispatch said that he was armed, right? Let's say that the dispatcher had not conveyed that information, right?
Okay.
Would that change your analysis?
No. Because there was enough other information aside from the fact that you just identified. There was enough other information that would give Lieutenant Lee the ability in that circumstance to fire. Again, look at the cases like Sanzone and Brummett, which say an officer cannot instantaneously process that kind of rapidly evolving situation. Something the district court specifically said was present in this case. They specifically said there was a rapidly evolving, tense situation. And in this instance, he just didn't have that time. He knew all of these facts about Mannery. This was not just some random suspect. He knew a lot about Mr. Mannery, far more than the officer knew in Brummett, far more than the officer knew in Sanzone versus Gray. He knew a lot. And that information all informs his question as to whether or not he can fire. And, you know, we have a case where an officer releases a dog actually after the suspect surrenders. And this court said that's permissible.
Was there
because there wasn't time to process.
Was there any evidence, because I couldn't find it, was there any evidence that Officer Lee thought that Mr. Mannery was reaching for a gun or doing something that would indicate that he would threaten the officers with a gun?
The only thing that's in the record that I can recall is at the very beginning of the encounter, when the Jeep is still parked, he fidgeted around in his pockets. So we know that he was doing something then. I don't know whether he ultimately was just reaching for keys or what he was doing. But I think that is probably the only evidence that would have suggested to Lieutenant Lee he may have been reaching for a weapon. I don't recall anything else.
I'm not sure why we're focusing on whether a reasonable jury could or could not conclude, based on this evidentiary record, whether this was an excessive use of force, because this is a qualified immunity appeal.
Yes.
So we can skip that first question.
Absolutely.
And we should skip that first question in excessive force cases, because invariably it entails discussions like the one that we're now having. What are the reasonable inferences, and what are the underlying evidentiary facts? And we don't have to decide that. We shouldn't decide that on qualified immunity appeals, and district courts should not decide that in qualified immunity summary judgment motions, they should just skip over the first question as Pearson permits and advises, as later Supreme Court cases advise the courts to do.
I agree
Westby
with you
and
100%.
others, and focus on whether it would have been clear, it was clearly established such that it would have been clear to any reasonable officer that firing a gun in this situation, assuming that a jury could find this as excessive force, just assume the merits question, whether it was clearly established that firing a gun in this situation was unconstitutional.
And there is no such case.
Right, so let's just focus on the proper question here. And that was the
I agree with you, Your Honor.
concern that, at least for me, with the approach that was taken in the district court here. And it's a very common error.
And I was, in my defense, I was trying to address Judge Lee's question.
Understood.
But yes, I agree with you.
Understood, but that's
Thank
what you
you.
should have led with. All right, Mr. Tate.
May it please the court, Brandon Tate for the appellee, William Mannery.
All right, and if you could start with my first question, which
Yes.
is really the key question here. Let's assume everything in your favor. Assume that a reasonable jury could find that this was an excessive use of force. Is this constitutional violation clearly established such that any reasonable officer in Lieutenant Lee's position would have understood that firing his gun under these circumstances was unconstitutional and unlawful and a violation of your client's rights?
Yes, Your Honor. To the court's question,
I'm
there
looking
are
for
two
a case,
cases.
yeah.
Yeah, so that was with regards to the, and I apologize, I have them written down a little out of order. That would be the Scott v. Edinburgh case and the estate of Starks v. Earhart, Ayart cases. These cases, and not only those cases, but also the general line of when there is no threat of imminent harm, deadly force of serious bodily injury or death, deadly force.
Scott involved an officer who created the risk. He stepped in front of the moving car. So that's not analogous to this case. That the Scott case would not have made it obvious to every reasonable officer that what Officer Lee's situation was precluded him from firing his gun.
Yeah, I agree that how the encounter occurred was different, but the premise and the law behind it, from our point of view, would be the same. The timing of the shooting was integral within that analysis. And the reason that we look at the Smith case as analogous is because it is.
I'm sorry, we're talking about all these S cases.
Yes.
So Starks is the one where the officer stepped in front of the car.
Yep, Scott, I apologize. Yes, that'd be the Scott v. Edinburgh case. So the officer stepped in front of the car, but he also, at the point in time that he shot, was not in the line of the vehicle. So the timing of the shooting was an integral fact within that analysis. With regards to, yes, Mr. Mannery, he didn't jump in front of Mr. Mannery's car, he did run after it. So I think that it could be inferred as to how Lieutenant Lee arrived within that, placing himself in the line. I think it could be inferred by a jury that he actually did do that. But
Again, this isn't a jury question, this is a legal question.
yeah, well,
So,
to an extent, it is the legal question, but kind of going to our motion to dismiss, it hinges on factual findings and to analyze the two cases together.
well, we have a video here.
Correct.
We have two videos.
Correct. And the court properly found in viewing those videos that they were clearly intertwined with facts. The qualified immunity determination is intertwined with factual disputes concerning threat.
Okay, it's a de novo review, so it doesn't matter what the court below found. The court doesn't make factual findings on summary judgment.
Correct, Your Honor. They infer
in the favor of the plaintiff
Right, so
in doing their analysis.
it doesn't matter what the district court said. What matters is what the video shows,
Correct, Your Honor.
right?
And the video shows an officer standing on the side, and I do want to point out there are 2 periods of shootings. So we're not talking about one shot, we're talking about 2 separate instances of shooting. He had the first 4 to 5 shots, a pause, and then another round of 4 to 5 shots.
Fraction of a second.
It was a pause, Your Honor. The initial shot took a fraction of a second. The entire shooting didn't take a fraction of a second. The way we review the legal aspect, and I won't go into Frommett and Sanzone, I think we briefed that, and the court would rather on the clearly established right. We do not view Scott v. Edinburgh as narrowly tailoring the analysis to a situation where an officer stepped in front of a vehicle. Because at the point in time that he fired the shot, the vehicle wasn't traveling towards him. And same as in this situation. And again, there's lines of case law establishing that when there's no threat of imminent harm, of serious bodily injury, which has been conceded, when there's be able to use deadly force, it's clearly established that you need to have imminent threat of bodily harm or serious injury to yourself or others on scene. That's enough, we believe, for clearly established rights in this case. Because at the point in time where the car is hitting the vehicle and stopped, and an officer is standing to the side, all 9 bullets went into the driver's side door. There's no reasonable officer that wouldn't know that's wrong. There was no threat faced at the moment of the shooting. How the law is situated is that even if you have a right to use deadly force at one point in time, that doesn't give you the right to use it over and over and over. It's a moment by moment. And we would contend that that moment ended the moment that the car stopped and hit that vehicle, and that it was clearly established because there was no imminent threat of serious bodily harm or death to any officer, to Lieutenant Lee, to any public figures. We do not, we would look at that as clearly established.
Based on which case?
The state of Starks v. Earhart, and we would view Scott.
That's the case involving the officer who stepped in front of the
I think I
vehicle
might
and
have flipped them.
created the.
Yeah, I might have flipped them when I was talking about them, Your Honor.
So which one are you talking about?
Well, I think the state of Starks does still. While he created it at the time of the shooting, the vehicle wasn't traveling right at him. And Scott was the same way. These cases establish that if there's no imminent threat of serious bodily harm or death to the officer involved, regardless of how they arrived at that situation, it's clearly established an officer cannot shoot into the side of someone's vehicle. That's what we're asking the court
But that's
to consider.
that's the Fourth Amendment principle stated at a high level of generality. You need to make it specific to this case and have a case that is analogous to this one, that would have put any reasonable officer on notice that firing a gun under these circumstances was an excessive use of force.
Well, Your Honor, I guess we would contend that both of those cases, as the district court found, do support that inference. I understand, may disagree, but we believe that those 2 cases do support the inference that would allow the jury to make a determination as to whether there was excessive force or not. I know I'm running low on time. We haven't talked much about the jurisdictional aspect throughout the argument, so I just want to briefly just mention that there is the aspect of whether qualified immunity has jurisdiction on appeal at the interlocutory stage, and that is when when it's not a pure question of law, but when it's also intertwined with the facts. And here, the facts are intertwined with how the district court handled this. And Smith v. Finkley is clear. It was a 7th Circuit 2021 case. Similar to this case, similar facts, as outlined in our brief, we would contend that the Smith v. Finkley case and the law regarding interlocutory authority over an excessive force qualified immunity claim, here the facts are too intertwined with qualified immunity analysis, and it's not a pure question of law. Simply saying you accept the facts, but then arguing the facts with the inferences toward yourself, it doesn't jive with what we're looking at on interlocutory appeal. You know, it's noteworthy, the district court even noted, this doesn't mean that they're definitively not entitled to qualified immunity. What they noted was they just want some facts determined by the jury, and then they very well could be entitled to qualified immunity. We're not at the end. So there is still the chance that the district court awards qualified immunity to the defendant. And for those reasons, we would request that the court affirm the district court's holding, and unless there's any other questions.
Thank you.
Thank you, Judge.
Mr. Overholt, I think you ran out of time. You can have a little extra time in rebuttal.
Counsel has failed to identify a clearly established case that would put Lieutenant Lee on notice that what he did in that split second after the car hit the police car, that what he did was clearly unconstitutional. There is jurisdiction in this case. The district court simply got the law wrong when it determined that he had to know instantaneously in that split second, he had to stop and reassess. Brummett says he didn't have to do that, and he didn't. For that reason, at a minimum, he is entitled to qualified immunity. Thank you.
Thank you. Thanks to both counsel. The case is taken under advisement, and that concludes our calendar for today, so the court will be in recess.